Yoon So Kim, Ina University Law School, Incheon City, Republic of Korea. He is going to speak to us on passage conflicts in the South China Sea between US and China in the Law of the Sea Convention. And thank you. Please come. Say that Professor Inza, I have not been able to mention his publications, etc., but I'm sure he has written quite extensively and then been teaching.
Good morning, everyone. Oh, it's it's my great pleasure to have an opportunity to make a presentation here in India. And I would thank you to in Associate of International Law and particularly Dr. Sonil for their kind invitation to me. So it's my great honor to meet you. And today, as you can see, I'm going to talk about the conflict between US and China in the South China Sea. So hard issues now. So we're so keen to as well. So I'll just briefly introduce what's going on in the South China Sea between two nations. Yes, my presentation is divided into 6 parts. On outline, navigation issues, state practice, legal status of maritime features in the South China Sea. So many maritime features in the South China Sea. Oh, it's time out now? Also Pacific conflict, and to conclude my presentation. It is so hard issues and so difficult ones, so I just quickly remind and quickly introduce what the problem is. How can we resolve the problems in terms of international law? As you can see, that South China Sea is a huge area, 3.5 million square kilometers. It's 1/3 of maritime shipping routes. So many ships are passing through the South China Sea area. So it's also one of the major choke points. And, that's why two nations are so keen to control the South China Sea areas. And also there are so many huge amounts of oil and gases are deposited. So we need to develop some kind of natural gases and oil as well. In terms of the international law, there are some 4 types of passage regimes. As you know, it's inner passage, trans passage, archipelago sea land passage, and free passage. But today I'm going to talk about just 2 passage regimes. These are just related to my topic presentation. So inner passage through territorial sea and free passage in the high seas. The right of innocent passage. Yes, all ships have the right to pass through the territorial sea of the coastal states. But there's some condition. Passage should not be prejudicial to the peace, ocean order, and security of the coastal state. If they did, they violate, it will be punished by the law. International law and national law as well. So passage should be continuous and expeditious. Just moving fastly through the territorial sea. So these are some relevant articles in the UN Convention on Law of the Sea. And of course, your ships should not do the following activities. If some ships conducted some kind of the following activity, it will be a violation of national law and also international law. So 12 activities are to be prohibited by the law. Next, I'm going to introduce just freedom of high seas. Yes, on the high seas, we may enjoy all freedom, navigation, overflight, installation of some cable cable line, pipeline, any kind of freedom ought to be given to all ships, all nations. One of them is freedom of navigation on the high seas. So these are some relevant articles in international law. Look at that. It's drawn by, it was drawn by me, by myself. So that's a small artificial island. Yes, of course, on the high seas, some state may construct, may build artificial island on the reef, on the rock, any other maritime features. But artificial island is not an island or rock in international law. That means it cannot generate any easy territorial sea or contiguous zone, continental shelf. No. It may just, coastal state may generate just 500 meters safe zone surrounding area of the artificial island. That's it. Artificial island is not an island in international law. So the surrounding area of the artificial island is just high seas, namely international waters. But some countries does not agree with that, particularly China. That's why two nations, and US and China, had big trouble, big conflict, how to interpret the legal status of surrounding area of the artificial island. China claims that will be our territorial sea. USA claims, oh, that's not a territorial sea. It's just internal waters. So we enjoy the freedom of navigation. There's a big conflict between two nations. But there's some controversial issues regarding the passage of foreign warships through the territorial sea of the coastal state. Still controversial, still not agreed. Of course, there's no any detailed provision on the issue of how to navigate through the territory of the coastal state by foreign ships in international law. But so many countries, not many, so some countries try to restrict the passage of foreign warships in the territorial sea of themselves. But nonetheless, almost 10 countries do not require any restriction on the passage of foreign warships in their territorial sea. But as you can see, the 36 countries need some kind of measures to the foreign warships which want to pass through the territorial sea before entering into their territorial sea. So-called pre-notification or pre-authorization, they need. But unfortunately, there's no any clear measure, clear provision on the issue of foreign warships passing through the territorial sea. That's why some conflict between international law and national law. So some countries try to restrict, need to some kind of clear measures to the foreign warships. Why? Because their passage itself may threaten the security of the coastal state. So big, there's some big, maybe there's some gap between international and national law, and also there's some conflict between two laws. So still, the basic reason why that happens, because they have different interpretation on the provision regarding the passage regime in international law. So, each nation has its different status, state practice on the passage itself, passage regimes. Why? Due to different security regions, different political regimes, and also different military powers. There are so many factors which will be taken to affect the minor countries' restriction on the passage of foreign warships. So now let me move on to the legal status of maritime features in the South China. There's some, as far as I know, 85 maritime features in the South China Sea. most of them are just small atoll, shore, low tide elevation, are just few islands. So look at that. This Chief Reef, it's just low tide elevation, LTE. LTE is not an island, it's not a rock. But China built some constructions on the reef and then claims, oh, this is our is a island, so it may generate 200 mile EJ. That's it. It's a big conflict between other countries. Theory Cross Reef as well. That's a reef. Reef as a national territory. It's just small on the feature. Maybe just low tide elevation. LT just means we can see LT only at low tide. On the high seas we cannot see it because LT is submerged on the high seas. And second Thomas Shore as well. Carbon reef as well. It's a mechanical reef. It's all are just reef. It's LTE. So, but nonetheless, China built huge constructions on the reef. They claim some huge area we told them by Egypt. And Johnson Reef as well. Portland Reef. So, of course, 2016 South China arbitration already got ruling on the legal status of reef on South China Sea. They are just a reef. They are not an island or rock, so they cannot generate any 200 mile EJ. It was given by the international court, but nonetheless, still China does not give up, does not follow the ruling done by the international court. So it is quite unfortunate. So let me turn to the Pacific conflict between the U.S. and China and the South China Sea. This is my core content on my presentation. Film navigation operations. U.S. Navy have been conducting film navigation on the high seas since 1980s. So USA Navy's consistent policy on the conduct activities. So USA strongly claimed that on the high seas, regardless of civilian ships or military ships, they have the rights of freedom of navigation in international waters or in the high seas. So they strongly against some countries wanted to restrict some kind of passive regimes in the high seas. USA so unhappy with that, so strongly protest against it. So one of operations, there and in 2000, it's 2015, US Navy phone-up operation conducted in the South China Sea, increasingly. So, but from now on there, and the two nations conflict was started since 2015. In 2018, USS John McCain passed through the, close to the artificial island built by China, named Mississippi Reef. And then China strongly against the USA phone-up operation. So China said it US violate international law and also China's national law as well. So also it seriously harmed the Beijing and China. So in 2018, USA strongly protest against USA phone-up operations. But nonetheless, USA Navy continuously conducted phone-up operation several times. But in 2020, 3 US Navy ships, naval ships, tried to pass through the surrounding area of the artificial island built by China. USS Montgomery, USS Berry, and USS Bunker Hill. Still going on. But still, conflict between two nations are existing. But let me just introduce how China reacts against U.S. for now operation. Let me just introduce some relevant domestic law of China. The law on the maritime traffic safety in 1984, China clearly required foreign warships needed to obtain prior authorization from the Chinese government if when they want to pass the territory of coastal state, I mean China. So China needs pre-approval, pre-authorization before entering into the territorial sea of China. And also the law on the territorial sea and the constitution in 1992, same one. So China also require prior permission before entering into the territories of China by foreign warships. But still some problems. According to the international law, I mean, according to the UN Convention Law of the Sea, there's no any exact provision on how to restrict on the passage of foreign warships. But nonetheless, some countries require some kind of the notification of the authorization of foreign warships. That's why it says a big conflict between international and national. So, especially when China ratified the UNCLOS in 1996, China made a declaration with the following sentences. A foreign state to obtain advance approval from or give prior notification to the coastal state for the passage of its warships through the territory of the coastal state. China strongly backing up the some kind of measure should be done before entering into the territorial sea of the coastal state by the foreign warships. This is China's basic principles, a basic policy on passive regimes. So I will conclude my presentation on the issue. Yeah, still, inner passive regime is already established in international law, but they have some countries have some different interpretation on the relevant articles on the inner passive regime. That's right. So there's no any ample state practice on the issue. Of course, it's just one, just a small number of international judgments already showed up, but still not ample. So still remains subject to the interpretation of the relevant articles of the UN Convention on Law of the Sea. So of course, many coastal states, I mean just minor countries, try to restrict some kind of measures to the against the foreign warships because it may threaten the security of the coastal state. I don't understand, but understanding is not different. Is different from legal law itself. So we need to clarify the quite ambiguous provision in international law. Because international law is just a multilateral agreement. So inevitably, it may have some ambiguous articles. So how to make a gap narrow between the constant state? That's why we have. So we need to improve and harmonize say practice, international law and national law. It's quite important one. Without harmonization between two laws, how can we solve the problem? And so we need to make an effort to eliminate some kind of difficulties in implementation of some relevant articles in international law. And I'd like to introduce the following interesting sentence provided by the UNCLOS. So, state shall refrain from any threat or use of force against the territorial integrity or political independence of any state or in any other manner inconsistent with the principles of international law. there's a law provided by the international rule of law. I mean, the corruption laws. So we need to remember, we need to bear in mind this kind of essential, crucial sentence. So we need to make an effort how to harmonize different national policies and also different interpretation on the festival. That's all I have. Thank you very much.
Yeah. So we have the next speaker, Dr. Park Young-pil. He is the director of the Law of the Sea Research Division, Korean Maritime Institute, Republic of Korea. He is going to speak to us on fragile stability of the legal order in the East China Sea. So we look forward to it. Please.
Thank you, Chair. First of all, I would like to express my sincere thanks to the President of Indian Society of International Law and all members of the ISIL, especially Dr. Bhawan for the wonderful arrangement. Yeah, I want to share my perspective or understanding on the legal states or jurisdictional issue in the East China Sea with you. As you may know, the East China Sea is not big sea. It's a relatively small sea. It is surrounded by China, Taiwan, Korea, and Japan. Only surrounded by 4 states, and there is only one territorial dispute. As we know, the Senkaku Island or Diaoyao issue, but there is no maritime boundary delimitation here in East China Sea. So when you look at this map, it looks very simple. So it seems there is no controversial issue in East China Sea. But I will try to do it. It is not. I think there are 2 factors maintaining stable legal order in the East China Sea. One is provisional arrangements under the circumstance there is no maritime delimitation, and the second one is so-called principle of self-restraint. And so the provisional arrangements and the principle of self-restraint are supported by UNCLOS Article 74 and Article 83. There are several relevant international cases also. First, look at the provisional arrangement in East China Sea. There are 2 types of provisional arrangement. One is fishery agreement, and the other one is kind of joint development agreement for the oil and gas. And this map shows the provisional arrangement for fishery agreement. There are 4 fishery agreements. One is by Japan and China, and Korea and Japan, Korea and China, and lastly by Japan and Taiwan. All these fishery agreements established provisional measure zone. It's kind of joint fishing zone. Uh, in the provisional measure zone, state can control only their own vessels. That can control they cannot control the other country's vessel. So East China Sea mostly uh, maintained by I think this provisional measure zone, and the other type of provisional arrangement is joint development zone agreement. In 1974, South Korea and Japan concluded a joint development agreement, and it entered into force in 1978. It will be effective for 50 years, so until 2028. And Japan and China also signed an understanding in 2008, but it is not legally binding documents. Anyway, in the East China Sea, for the exploration and exploitation of oil and gas, these two provisional arrangements are maintained. Yeah, the other one is the other one that makes the East China Sea stable is kind of self-restraint. And when the South Korea and Japan established a joint development zone in the East China Sea, Chinese government protested, claimed that it belonged to its own continental shelf. But China has never encroached the joint development zone. I understand it's kind of self-restraint. But I think that, there are at least three factors making unsustainable the stable legal order in the East China Sea. The first one is China's incremental expansion policy or assertive policy, and Japan's presumed policy change from self-restraint to assertive. And the second one is the limit of the provisional arrangement system in the East China Sea. The third one is the possibility of the termination of the joint development agreement between Korea and Japan in 2028. So let's look at these three factors. First, China's assertive policy and Japan's presumed policy change. China has recently adopted, enacted the Chinese maritime policy law, and it also amended the maritime traffic safety law. Just previous speaker there, Professor Kim, Hyun-soo Kim, explained these two laws very well, so I will skip the content. And the Chinese government also very increasingly conducted marine scientific research in Korean side, in the waters that belong to Korean side from the Menon line. And Japan also recently changed the policy from restraint to assertive. For example, on the right side of the map shows the gray area, because the Koreans claims the Menon line between the Menon line claimed by Korea and the Menon line claimed by Japan is quite different. So it shows the gray area. So, but until quite recently, Japanese government very hesitated to conduct counter enforcement jurisdiction in this area. But recently, Japanese government tried to introduce some impulsive jurisdiction in this area. So we are very cautious to look at the situation and whether it is the fundamental change of the Japanese government policy on the East China Sea or not. And the second one is the limits of provisional arrangement in the East China Sea. The left side, the map shows the very complex overlapping plains. The pink line means the joint development zone between Korea and Japan, and the slashed line is provisional measure zone between Korea and Japan, and the gray color, a very big area, is the provisional measure zone between China and Japan, and the dotted line means the provisional or tentative median line. So when we draw this line, and we can analyze the legal status of each zone. So there are at least 14 different zones from the perspective of jurisdiction. So this that shows that there are very, very complex overlapping plains. For example, the yellow on the right side, the yellow color shows that there are two there are overlapping claims by two countries, and also there are seven zones claimed by three countries: China, Japan, and Korea. So it is a very, in my opinion, it is a very fragile jurisdiction system in the East China Sea. And the last one is some partial termination of Korea-Japan JDZ Joint Development Zone Agreement. As I mentioned already, it can be terminated by one country in 2028. The Japan's position is that most of the JDZ belong to Japan under the UN Convention on the Law of the Sea, 1982 convention, when it draws the median line. So the distance between the two coastlines is less than 400 nautical miles. So the basic position of Japan's government is that there is no, we don't have to consider about the natural prolongation of land mass, and so just draw median line. So when we accept the Japanese government position, most of the JZ can belong to Japanese side, right? And then if Japan's government notified to Korea to terminate this agreement, then there is not this kind of provisional arrangement. So in this case, the Chinese government also can encroach in these areas, because in 2012, Chinese government already submitted information to the CLCS, Commission on the Limit of Continental Shelf, to extend its continental shelf beyond 200 nautical miles. So in East China Sea, if the JDZ agreement terminates, Chinese government will claim that it both of the JDZ belong to Chinese side. So in this case, we have to face some very, very controversial maritime delimitation issues. So I think it is one of the very fragile statements. So this is all my presentation. Thank you for your attention.
Thank you very much, Dr. Park Young-kil, for that excellent presentation, and it actually spoke about the fragile stability of the legal order in the East China Sea, particularly the cooperation that exists between Japan and Korea is very interesting. Long-term agreement, 50 years agreement. I'm sure it will be renewed again, I suppose, unless, of course, there is some serious other issues involved. And let me invite Captain S.S. Parmar, Senior Fellow, National Maritime Foundation. He is one of our well-known experts on law of the sea, and he will be speaking to us on balancing UNCLOS in the contemporary security environment.
Okay, good morning, ladies and gentlemen. It's a pleasure to be back to ISIL after the lockdown period. The last we met was 2019 or early 2020. We again discussed UNCLOS, and my thanks to the organizers and a warm welcome to our friends from Korea, especially Professor Kim. Thank you. You covered a lot of aspects that makes my job easier. It goes to the point that I am going to end my presentation that there is convergence within divergence, and that's a term I'd like you to hold on to for some time. So what I'm going to do is I'm going to take you through certain discussions of UNCLOS. Then we will look at certain aspects of what is the contemporary security environment, and I'm going to focus it based on the Indo-Pacific, which is the flavor of the season. We have almost everybody jumping it on board, with Italy yesterday coming on board the science, academic and technology pillar. So we've got many more people coming in. South Korea itself has come out with its own Indo-Pacific strategy in December, and Canada last month. So there's a lot of things that are happening. Therefore, we need to look at UNCLOS in a more convergent manner. Having said that, let me take you back to UNCLOS 3. To be very clear on this, UNCLOS 1, if you recall, had a number of conventions, and UNCLOS 3 had one convention. It's one running convention, which made the job easier. And that is the reason why there's certain figures. When you look at the number of conventions of UNCLOS 1 that related to national resources, the number of nations who ratified it were much less. Just keep that in mind when I look at the UNCLOS into implementing agreements, and you will see the reduction in numbers. But having said that, certain aspects that Professor Kim covered regarding sensitivities and how nations looked at certain aspects, there were a number of diverse groups and internal intense debates that were held. If you go online to the UN library, you will find that the whole UNCLOS 3 debates, the whole record of discussions are given. We are fortunate in NMF to have a hard copy of all of that, which was handed over to us by the late Rear Admiral O.P. Sharma. Before he passed away, he was the last surviving member of the Indian team that attended all UNCLOS meetings. So when you look at that, you do realize that this was the breakdown of the nations, and you can identify which group would have been in what grouping when a certain aspect concerned to UNCLOS was discussed, and more so with innocent passage having been discussed. That's still a big bone of contention. So you had the developed nations versus the underdeveloped and developing nations on various issues. The US-led group, or the capitalist group as it was called in the Soviet bloc, or the communists. You had Asian nations, you had Latin American nations, you had West Asian nations, you had African nations, you had island and archipelagic nations, which could form any of the above categories. And of course, with UNCLOS saying that even landlocked nations have a right to the seas, you had geographically disadvantaged and landlocked nations. When you look at the third bullet onwards, most of the nations who had a convergence on many issues regarding things like innocent passage of military activities in the EZ were those nations who got independence after World War II, and of course also they were free from colonization. Sovereignty was a major issue, which still is, and that is why the reason why you have certain restrictions placed by nations regarding innocent passage military activities, because having been through centuries of colonization and seen the after effects of World War II, and there was a voice that was emerging 30 years, 40 years after World War II when UNCLOS 3 was being discussed. And those voices have gained strength on the international table today. India is one of them. So therefore the stances are unlikely to change, but we need to look at how to balance UNCLOS in the contemporary security environment. Having said that, what do I mean by the contemporary security environment? These are questions, not rather statements. Is it something that's governed by a rules-based order, as is spoken out today? In which case, the counter question to that is whose rules? Is one issue. But since we seek a free and open Indo-Pacific and India's added word of inclusivity, therefore, we look at a rules-based order that is advantageous. Having said that, let me make a statement. We live in a world of realism. Therefore, all nations will interpret international laws and conventions in support of the national interests. That is rule number one. There is no rule number two. Having said that, rules-based order, when it's convenient, we follow it. We have a lot of statements out there by various nations, and therefore, in the maritime domain, a subset of this is freedom of navigation. And that's something that Professor Kim had alluded to, is that freedom of navigation means that if you go by mare liberum, then the ocean is free for use by anybody. But UNCLOS 3 put certain conditions which were based upon the maritime zones that were there. How far the nations adhere to them is again based on the interpretation. Then of course, there are varying interpretations of UNCLOS. I've already made the statement. So is this a spoiler? Perhaps in the initial days when the rising voices, as I said, of now the nations say like India, Japan, Korea, were perhaps a very minor echo in the halls of power and wherever international conventions took place. But are these varying interpretations a spoiler? And this is something that I will address in subsequent slides. So therefore, we look at what are the players today. Is there a dominant Western view? If we go by the discourse of rules-based order, there is one narrative out there says that this is a dominant Western view. What about a rules-based order that existed in the Asian civilizations that were part of Asia many, many centuries ago? There are alliance partners, there are allies today. When you look at the US South Korea, US Japan, they are allies. Now you have something which is called third party players, and they adhere to strategic autonomy. India is one. I would dare say I'd like to add France in that camp of supporting strategic autonomy. And therefore you have this grouping which is, they are called strategic partners. In international relations terms, around 2-3 decades ago, this term was not a very well-known term. It has now gained impetus. So you have alliances, or you have allies, and you have strategic partners. And general difference in view of UNCLOS comes when you have strategic partners and one or two allies. Then you have authoritarian regimes. East Asia is one area which has got two authoritarian regimes there. And then, of course, all these players are governed by domestic conservative constituencies. So if the US has not signed and ratified UNCLOS, they always say that there is a domestic constituency that is stopping them. All presidents since Ronald Reagan have said that yes, we must sign and ratify UNCLOS. It has not happened. So in the Indo-Pacific specifically, so we've got China and Russia who oppose the notion of the Indo-Pacific. They also oppose the issue of various interpretations. They have their own of UNCLOS. A lot of it has been mentioned by my Korean friends today. Then you have allies versus strategic partners. And what we see today is a mushrooming of bilateral to minilateral, a mix and match of quads. I'll give you one example. You have a minilateral which has come into vogue. That is India, Israel, USA, and UAE. Hang on to these four names when I tell you, when I show you the slide that depicts who was ratified and not ratified. Because in this quadrilateral, or the four, or the minilateral of four, there is a different stance on UNCLOS. So if these four nations are going to look at UNCLOS, it's going to be a very interesting debate to see how they approach it. But I will tell you the stance of these nations when we come to that slide. So what is the position of UNCLOS? This just maybe a little background. Let's say there are three main parts of the UNCLOS in a nutshell. One is the main document of UNCLOS, which has the number of articles and the number of sections, and of course it is there. There are two implementing agreements. One is the 1994 agreement relating to the implementation of Part 11, that is the area, that is seabed, subsoil, thereof beyond national jurisdiction, that came into force 96, and the second is your fish stock agreement of 95 that came into work in 2001. If we look at these three as a composite package of UNCLOS, you can't look at only UNCLOS alone, because the two implementing agreements support UNCLOS itself, and therefore they look at certain resources and of course the seabed. Today this figure is 168 nations or parties have ratified UNCLOS, 151 have ratified Part 11, and 91 have ratified the fish stock agreement. If you compare this with the number of conventions that were signed in UNCLOS 1, you'll realize that when it comes to seabed and resources, the numbers of ratifications reduced as is very evident. As far as the main text of UNCLOS is concerned, you have 14 nations who have signed but not ratified. 16 have not signed nor ratified. Among the 14 who have signed but not ratified, 7 are landlocked, so let's not look at them. What you have is Cambodia, Colombia, North Korea, El Salvador, Iran, Libya, and UAE. Please remember the 4-nation minilateral I had mentioned. So UAE has signed but not ratified. Of the 16 who have not signed nor ratified, there are 9 that are landlocked, that include the Vatican. And so the ones who are not landlocked is Eritrea, Israel, Peru, Syria, Turkey, US, and Venezuela. So in this minilateral of India, Israel, USA, and UAE, these are the stances. India is the only nation who signed and ratified. In a similar fashion, when you have a look at the bilaterals or the minilaterals, even the multilaterals that come about, and you have, say, a discussion on UNCLOS, this is the background to which the nations will be coming from. As far as the US is concerned, it has signed Part 11, but it has not ratified it, but it has signed and ratified the fish stock agreement. Since China is the flavor of the season, China has signed the fish stock agreement but not ratified it, but it has signed and ratified the implementing agreement and UNCLOS. So whenever the US and China get into a hot debate, China says sign UNCLOS, ratify it, and then come talk to us. So this is again where you need to have a certain convergence and divergence. And if we are looking at today, India and the US are great global strategic partners. This is an example I will cite when I come on to the rest of the slides I have here. So back to UNCLOS. We can argue that the 2 main pillars of UNCLOS is sovereignty and freedom of navigation. If UNCLOS was based on the fact, was established with due regard to the sovereignty of all states, and if I remember correctly, it is para 4 of the preamble that mentions this line. So therefore, sovereignty means that UNCLOS will recognize maritime zones provided the sovereignty of the land which is claimed by a particular nation is accepted internationally. This is a grey area insofar as disputed areas of lands go, and that is the case in the South China Sea and in the East China Sea. That if the sovereignty is not recognized, then whose maritime zones will be recognized? There are a lot of ICJ rulings that state that the accepted principle of international law, that sovereignty of land, is the basis for determining maritime rights. So even before UNCLOS came out, there were certain ICJ rulings. These also extend to Europe. So it's not only Asia that has had this problem, but even Europe had faced this problem earlier. Still is actually, some of them. So there are varying interpretations based on sovereignty issues, and I'm going to concentrate on only 3, the paucity of time. One is baselines. One is military activities or exercise activities in EZ, and the second is the innocent passage for warships, notification or authorization or permission, as was mentioned by Professor Kim. And what is the impact on the freedom of navigation? The islands were clearly mentioned. So if China says that these islands belong to me, and therefore you are not following my interpretation of UNCLOS as far as innocent passage is concerned, then today are we looking at a possibly growing conflict which will result between the balancing of sovereignty and freedom of navigation? In 2019, at the Shangri-La Dialogue, the Chinese Defense Minister clearly came out in support of the reclamation of islands and the arming of islands, saying that because of the presence of warships and aircraft, which is a reference to the freedom of navigation operations carried out by the US, how can we not defend ourselves? Words to that effect. It is very clear that in case China feels threatened or feels that it has been a subject of armed attack as per the UN Charter, it will react in self-defense, which is as per UN Charter Article 4. My personal belief is China will never fire the first shot, but it will force a nation to do something so it can react in self-defense. So is there a growing conflict between sovereignty and freedom of navigation which may result in a conflict? Today in the South China Sea and East China Sea, it's like a powder keg. It can ignite any time. One wrong move anywhere and we may have an incident at sea or in the air. We've had a number of them earlier, but it only grows. Friction, does it exist? I would definitely say yes. So a lot of nations, as per Article 310 of UNCLOS, have deposited statements. Some of them has been mentioned by Professor Kim. I'll just cover them. Or the national laws of various nations, India included. but still there are alignments in the Indo-Pacific as far as EZ and Universal Pacific. I'll just reflect on that in a bit. India, in the Maritime Zones Act of 1976, very clearly said that foreign warships, including submarines and other underwater vehicles, may enter or pass through the territorial waters after giving prior notification. If you read the writings of Admiral O.P. Sharma, the initial discussion was approval, if I'm correct. I'm open to correction here with the learned audience sitting here, but I think wisdom prevailed and it was changed to notification. 1976 predates UNCLOS. Obviously aligned with the main tenets of UNCLOS which were under discussion, but it has been subject to India's national interest, and that is clearly reflected. And this MZI Act has been deposited with, give me 2 minutes more? Okay. And then of course with EZ we'll say that India understands the provisions do not authorize other states. And this is a statement we had deposited. And since we have South Korea here, and I'm open to correction, South Korea says foreign warships or other government ships operated for non-commercial purposes to notify particulars not later than 3 days prior passage, and that is the subject of the approval as per the South Korean government. This stance of South Korea. Straight baselines. The next 3 maps I'm going to show you are straight from the US Navy Judge Advocate General website. Please look at the right top notation. The US does not recognize the straight baseline claims of South Korea. Yet the US and South Korea are allies and they operate together. Similarly is with Japan, in the same case. So I often ask my US friends that you object to the baselines, but you very happily operate from the ports and airfields which are situated within those baselines which define the national territory of both the countries. This is India, just to give you an example. Again, the straight baselines are not reflected. So these are baseline issues that come about. US freedom of navigation reports, they do it for excessive maritime lanes. They are mandated to render an annual report to the US Congress. In the fiscal year 2021, the US carried out freedom of navigation against these nations. Please note, India, Japan, South Korea reflecting. This is a snapshot of the number of times the US has carried out F1 CONOPS against India starting from 92, and the reason was 2019. The reasons are given there. They do this every year, and you'll find that South Korea, Japan, other allies and strategic partners find mention. But yet, today, we are global strategic partners. Alliance between South Korea, US and Japan, US grows stronger. So I come back to my point. In the better good of operating together and in the Indo-Pacific, there is convergence with divergence. We need to step aside from certainly looking at certain aspects that are little bugbears, but for the greater good, I think we need to work together, and that's what we are doing. So nations act on the basis of national interest, domestic pressures that have been covered. These outweigh international obligation. That's something we need to recognize. Greater powers periodically act outside international legal regimes for the simple reason that they can militarily and economically accept the cost of transgressing rules-based order. Middle and small powers are generally content to stay within the existing order. I dare say we can put India, South Korea, and Japan and many other nations in that. There is a greater respect for international conventions, especially UNCLOS. So in today's contemporary security environment, this is my last point, we need to seek convergence within divergence to address bigger threats and challenges which overshadow the whole aspect of UNCLOS. And I leave you with my favorite quote from Eisenhower, that history does not long entrust the care of freedom to the weak or the timid. Freedom of navigation is essential. Thank you so much.
Thank you, Captain Parma, for that excellent presentation on the law of the sea and security related issues. Now I have a very pleasant duty to shift my chair to Dr. G.V. Rao, Senior Advocate, Supreme Court, and also the Vice President of the Indian Society of International Law. He is back now on the chair. I welcome him, and I am asking him to, I'll be happy to hand over my baton to him. Thank you. He will conduct the further proceedings, and then we have to finish by 12:10. We have 2 speakers.
Good afternoon, everyone. I must apologize for coming late. Today is a weekday. I'm a practicing lawyer of the Supreme Court. I had a hearing at item 1, which promptly started at 10:30, and for some reason, because we were a little tight about the timings, the session was fixed without checking my convenience on this, and it was, as you know, all of you must be knowing it was a bit last minute. But anyway, I'm very glad and I'm thankful to Professor Hegde, whom I'm asked to stand in, and on this wonderful area of law, the law of the sea. As you know, all international law started from the law of the sea, of freedom of navigation and all of that. And the sea, as you know, is a common heritage of mankind. All of the, essentially, the origins by Hugo Grotius is from the law of the sea. So all international law has this foundation and basis here. And we have a wonderful panel of speakers, but I must apologize to them and welcome them as well. Professor Hun Soo Kim of the Inha University Law School in Shin City. I'm sorry, it's my loss that I missed your presentation, and I'm sure I will see, since it's all, available on YouTube, it can be seen by anybody who has missed it. Of course, Professor Dr. P.S. Rao, who was one of the chief founders of the Indian Society of International Law. He has been an ad hoc judge at the International Court of Justice. You must have heard him in the morning. Madam Neeru Chadda, I believe, could not come. She's a judge at the International Tribunal of the Law of the Sea in Hamburg, where Thomas Hyder, I don't know if he's still the president, he was my teacher. I'm a Rhodes Ocean Scholar, and I did the program on the law of the sea in Rhodes in Greece, where the current president, Thomas Hyder, was my teacher. And of course, I knew the previous president as well, the Austrian gentleman, Helmut Turk, who later on become the chairman of the International Seabed Authority in Jamaica. Also, Dr. Park Yung Kil, Director and Law of the Sea Research Division. Welcome, sir. I'm sorry I could not be present to welcome you, but now I do. And Captain Parmar, who is one of our leading experts in the National Maritime Foundation. You heard his erudite talk on balancing UNCLOS. As you know, UNCLOS is the foundation of all of the law of the sea. It requires so many changes. I have been talking about amendments, which in those days, which I thought it required. They said it would take a long time, but I think today, with the advent of technology, it may be easier and faster if we attempt it. There are some flaws. Of course, the United States, I always said at this very venue many years ago, when one of our Undersecretary Generals to the UN had come here, and I said the US fashions itself as a democracy by itself, as one of the greatest democracies in the world, but in the community of nations, it behaves like an authoritarian person, and it doesn't give regard. It's not signed the UNCLOS and the Kyoto Protocol and other things. So I guess the United States should, get to be a more cooperative person in all of these areas, and we hope that they would do it, and to the betterment of humanity, of mankind. As we know, David Parado, you know, the man who described it as the common heritage of mankind, the ambassador of Malta in those days. So thank you, Captain Paraman. Now I would like our good friend and expert in the law of the sea, Dr. Sunil Agarwal, who is a life member on the ISL. He shall be speaking on India's submission before the Commission on the Limits of Continental Shelf issues. And welcome. Please. Thank you.
Thank you, sir. It's my pleasure to make a presentation on India's maritime claim, basically the extended continental shelf claim in the Arabian Sea. That's the topic that I have chosen, just to highlight the dynamism that we have in international law, especially in the law of the sea. The law of the sea, as we all know, reflects basically the geopolitics, it reflects the dynamic interest of various countries, as the varied interpretation of international law, as well as the implementation part, because law of the sea is very much related with the maritime affairs, which are real in nature. unlike the other kind of sub-disciplines of international law of the sea is very much alive, and we see most of the activities happening in the maritime domain, from the ship emission to say the issues like freedom of navigation. The freedom of navigation is a very important issue. It, in fact, the law of the sea owes its origin from the freedom of navigation issue only. And another important issue that is there is basically the maritime boundary. As you know, the oceans have no boundary, so there are so many disputes. And one of the disputes that we have is that we have under India-Pakistan maritime boundary dispute, and this is the highlight of my presentation. So I begin by saying that the UNCLOS has a role in the energy security as well, besides the freedom of navigation. In fact, the recent global energy crisis triggered by the Ukrainian that crisis that we have after this Russian invasion of Ukraine underscores the primacy of energy security in the international geopolitical arena. As states compete for energy security, the coastal states are rushing to claim extended continental shelf to access the offshore oil and gas resources under the UNCLOS. And this is where the contentious issue lies. In fact, there are about 93 ECS submissions, that is the extended continental submissions. Before the commission, that there is under the UNCLOS, there are 3 institutions working presently at international level. One is the ITROS for the dispute settlement, another for the deep sea bed mining is the International Seabed Authority, and for as far as the continental shelf claims are concerned, because this is a very, very contentious issue in the sense that there are lot of evidence the coastal states have to corroborate with to claim their entitlement to the continental shelf. As we know, in the continental shelf, the coastal in the UNCLOS, the coastal states are entitled to 200 nautical mile, but to claim beyond that, they need to go before the CLCS. So that is the issue that we are discussing here. In fact, the CLC has adopted recommendation in 35 cases till now, including the Pakistan ECS claim. In fact, Pakistan was granted in March 2015. Pakistan was granted the ECS claim from 200 nautical to up to 315 nautical mile. Still, we are anyway. That was one of the case where the recommendation has been implemented. 9 submissions are under the consideration, and one of that the consideration issue submission is the India's claim in the Arabian Sea. All right, and the rest are still in the queue. As we know, this India submitted its ECS claim before the commission on 11th May 2009. That was if the experts know, the domain experts know, that was the time all the claimants have to, that was the last day in fact. I think 12 May was the last day. So they had to submit it. So somehow India also submitted, but it was partial submission. Anyway, in August 2000, after almost 10 years, just see, this in August 2019, CLC established a sub-commission to consider this claim in the Arabian Sea. Why? Because the CLCS also follows certain rules, and the rules are basically there are the rules of procedures. So accordingly, it took almost 10 years, a decade, to even to just for the consideration before the CLCS. And as Professor Park pointed out, we have the fragile situation in this claim issues as well, because nobody knows when this maritime delimitation is going to happen between India and Pakistan because of this delineation issue. All right. Just to give a brief on the CLCS, As we know, under the maritime zone scheme of UNCLOS, under Article 76 of UNCLOS, it provides the legal definition and extent of the continental shelf claim that can be claimed by the coastal states. Now, as I already mentioned, the coastal states have ipso facto or ab initio rights to the continental shelf up to 200 nautical miles, but they have to submit it mandatorily. It is mandatory if they want to claim more, up to two, that is maximum is to 350 nautical miles. So that is how it happens. As far as the CLC is concerned, it has been established in accordance with Article 76(8) and Annex 2 of the UNCLOS. Its mandate is to evaluate the scientific and technical data submitted by the claimant and to make a recommendation which is definitely binding in nature and final, definitely. To get this kind of approval, the coastal state needs to satisfy the test of apprehendance to claim this entitlement, and then only the decision would be there. Now, this is the data that have been submitted by India. This is the India's claim, in fact. The India's claim in the Arabian Sea. The outer limit of India's extended claim, extended continental shelf in Arabian Sea has been defined by state line segments. As we know, there are a number of methodology under the UNCLOS provisions wherein they define the base points, etc. So this one of there is a state baseline segment, not exceeding 60 nautical mile in length, connecting this 220 fixed points. So this is the data that has been submitted before the CLC. Among these 220 points, about 19 points, exactly 19 points, are located on the potential maritime boundary with Pakistan. This is the bone of contention, in fact. And for that, in fact, Pakistan has raised this belated objection, rather, because the submission happened in 2009. Now they have submitted this objection for the CLCS. So on 6 July 2020, after almost 11 years, Pakistan, when this matter came before the consideration of CLCS, they made the formal objection to the CLCS not to consider and qualify this India's claim. Why? Because Pakistan considers content that unless and until the Sir Creek issue is resolved, it is not going to be, it cannot be decided. All right. So this note verbal they sent to the UN 6 July, in which all this, they disputed the India's baseline, in fact, which fails to reflect, saying that it fails to reflect the Sir Creek dispute. And subsequently, the Commission took note of this, and as a result, in fact, in the last year, July meeting, all right, the CLCS Commission deferred the consideration of India's submission. This is the kind of geopolitical things that I was trying to point out. This is happening at the international level. Now, just to reflect on this Sir Creek dispute, which is a bone of contention between the two countries for a long, historically it is there. In fact, this Sir Creek is a kind of estuary located in the uninhabited marshland. This is a very peculiar geographical located in the run of Kutch in the state of Gujarat, all right, which separates the state of Gujarat from the Sindh province of Pakistan. So this is a very marshy area, very difficult to demarcate area, and in fact, this run of Kutch arbitration also, this was left out for various reasons. All right. So I'm not getting into that. Now this Pakistan contest, you can see this, if you can see this, I just wanted to reflect on this. This is a kind of what they say, pillar, because demarcation had taken place, but this area was not demarcated. This is the last demarcated, I would say, that pillar which is located there, which shows the nature of this area. Very, very fragile, very, very difficult terrain. So nobody even can be there. Now, as a consequence, this Sir Creek has been deeply, I would say, deeply militarized. Just give me, sir, 2-3 minutes. He has been deeply militarized and has been a hub of cross-border terrorism. It is a border area, so definitely there are so many cross-border activity, terrorist activity happens. In fact, Atlantic case, if you remember, that also happened in this area also only. So it's a very area which is still disputed. But this is a land. This is not. This is not the basically maritime dispute. That is the problem. Now, the India argues that CSCA submission is without prejudice to the matter relating to the maritime delimitation. So, whatever there are two issues in UNCLOS. One is the delimitation and is the delineation. So, delineation has to be done by the CLCA, not by the delimitation. Delimitation only can happen bilaterally or going to the dispute settlement. That is how the process happens. So, they are mixing up Article 76 with the Article 83 of the UNCLOS. That is the thing. I just conclude, sir. Now, this is, I would say, the delineation issue of the India's outer limits of continental shelf beyond 200 nautical miles has been marred with in the Pakistan policy to manipulate the international fora and mechanism to pursue geopolitical interests against it. It has happened in number of cases. They want to link everything with either Kashmir or whatever. So this is, I'm not getting into that. Just trying to highlight that this is how this issue, the geopolitics is also playing, underlies the kind of delimitation issues or the delineation process that happens. This is happening in the South China Sea also. This is happening in the, as Dr. Park pointed out very clearly, in South China Sea, East China Sea. In fact, this concept of joint development zones are there, but it cannot be followed unless until the both countries can agree. India and Pakistan agree, they can have, if they have the pending the delimitation, they can go for the sort of agreement which can have the joint exploitation of the resource. That is possible. Anyway, now my point is the CLCS needs to focus on, rather than getting into the politics, they need to focus on evaluating the technical aspect. According to the technical guidelines, it has got its own technical guidelines by delinking the maritime dispute from the land dispute. It is a land dispute basically, and because of which the base points are disputed. But that has not much, if it's not going to have much impact, very I would say partial impact as far the delineation issues are concerned. Now, with regard to India, I would say that they need to finalize its submission before the, to continuously prove its entitlement to continental shelf up to say 50 nautical miles to satisfy the technical scrutiny of the maritime claim. They cannot escape. There is a need for technical scrutiny. Finally, I would say if these sort of claims remain pending, there is a, it will have an implication for implementing that part 11 deep sea mining regime, because unless and until areas beyond the national jurisdictions are delineated, the International Seabed Authority will have problem in implementing this deep sea mining, which is getting now a lot of attention because of resource price. So thank you very much, sir.
Thank you, Dr. Sunil Agarwal.
Thank you.
Thank you for your presentation. Now I'll invite Dr. Utpal Kumar Raha of St. Xavier's University, Kolkata. He will speak on the topic challenges to the protection and regulation of submarine cables and strengthening municipal law as a way forward. Now submarine cables is big, these are big projects, internet connectivity and other kinds of things. I'm sure Dr. Raha will give us a wide understanding of the subject. Thank you.
Thank you. Very good afternoon to all, and very good evening to those who are attending and participating in this conference across the world. So I am very much interested to address those who are attending this conference in online platform, and this is why the importance of this topic. Pertinent question is, who provides necessary internet and telecommunication facilities? It is the submarine cables, what we say. So very precisely, I would like to introduce the the significance of submarine cables, then its challenges to legal challenges for the protection of submarine cables, and how law has going to address these challenges. Now, when you deal with the
I think you have 15 minutes. They are short of time. So. All right.
sir,
Okay. 10 minutes. I've been further by the chair in the next session.
I promise to complete within time. So, so very simply, let me, since it is like that, so quickly I go to the. So what this is the topic. This is way we globally we are connected across the world. The cables over 300 international cables are connecting each and every country's continents. These cables are connects between two landing stations across the oceans. Now my point is that these cables are vulnerable at its both ends, and these both ends of these cables falls under the territorial jurisdiction of coastal states, where the coastal states has sovereignty. That means the cable laying, repairing and maintenance operations are rest of the permissions and approval of the coastal state. So if we look at the UN clause, basically the Article 58, 79 and 87 of the UN clause prescribes the freedom of laying submarine cables. Now this freedom of laying submarine cables are meant for the high seas freedom. Within territorial water, whether these cables enjoys the freedom of submarine cables? Answer is no. So now these cables are, even though these cables are providing necessary necessary support, telecommunication, internet and transmission support, these cables are increasingly becoming vulnerable to damage by marine activities, both natural and anthropogenic. And if you look at this cable map, I just stick with this cable map, many of these international cables are passing through narrow passages of sea line of communication, or say Strait of Malacca, where number of international cables are laid in close vicinities. And these are the Achilles heel of international telecommunication system. It is exposed to maritime terrorist activities. If such unfortunate thing happens, international telecommunication system will be severely disturbed, and our economic transaction, our national states security matters based on this telecommunication system will be significantly disturbed. Now, if we look at the national measures, the countries are yet to take adequate measures to address the security issues and protection issues with the submarine cables. Mostly, even though we are taking these facilities, we are taking these facilities as guaranteed. So, mostly countries are not adapted with the legal and policy issues addressing or enhancing the protection of submarine cables. Apart from Australia and New Zealand, so the two countries across the whole world, they have adopted a dedicated legislation on the protection and regulation of submarine cables. Now, these Australia and legislation, besides two countries, none of these countries across the world have given much importance for the protection and regulation of submarine cables. So if we look at both of these countries' legislations, they have given certain parameters, certain importance for protection of submarine cables, that they have identified maritime submarine cable protection zone where they have identified certain matters, certain marine activities to be controlled, to be regulated, so that they can prevent from the cable damage. And even if there is a cable damage, there can be regulatory support, authoritative support from the coastal state in Australia and New Zealand, so that they can facilitate the the wrongdoers held liable, as well as give the necessary information to the cable owner. Now, on the basis of this existing, whatever regulatory mechanisms and legal policy issues are available at the domestic level, we can suggest that state, for its own interest, must adopt, must not no more neglect these cable protection issues and provide regulatory support to the cable operators. And therefore, they can develop certain guidelines, if not a full-fledged law. These guidelines may have three parameters. One is spatial approach of ocean management. Second one is demarcation of submarine cable protection zone. And finally, establishment of a dedicated authority, each and every country which can work on close connection with cable operators for dealing with these issues and challenges. Now, I would like to end this presentation saying that how India facing challenges in its ambition to become a leader in cyber platforms. In the Indian Ocean, in Indian subcontinent, India has strategic advantage in global submarine cable map, where India can be host country, or India can offer its platform to be a submarine cable depot, and therefore the submarine cable vessels, submarine cable operators can use India's the platform to be connected to deal with activities, cable-related activities in these important strategic positions. Now, India's challenge is here. India has this, is sensitive to its maritime zones. So, allowing foreign submarine cable operating vessels and their crew members to be operated within India's territorial water or exclusive economic zone, free from control or supervision, India is reluctant to, as a genuine reason, India has a genuine reason to not to allow its marine space freely for other vessels which are technically support, and these people can make use of this open platform. So India has a reason and its sensitivity to not to allow foreign vessels and open its window for cable operators, even though such thing can be addressed with close connectivity with cable operators, how it can be managed India's security concern, and India can emerge as a leader in submarine cable system and get a lead role in this region and beyond. Thank you.
Could have seen all of your presentation, but due to paucity of time, you have really focused on the core issue, and you have given us a diagram which shows how interconnected we are undersea, which is an amazing insight about how we have transformed over the years in terms of not only satellite communication but undersea communication as well. Even gas pipelines, for that matter, have been laid. Now, as we are very close to Dr. Narendra Singh would like to say something, but let me just say that we have a question answer or comment section for 5 minutes. Any one of you will make a quick question or comment to whoever you want, and may I ask Professor Hunsu Kim also to be sitting on the dais now that our president. I'm sorry, the panelists, we ought to have put some panels, screen panels here, so that the those who are on the dais can also be seeing the presentations, but we will make it happen. But Dr. Narendra Singh would like to come quickly. He's been our top officer in the Government of India as Joint Additional Secretary in the Ministry of Legal and Treaties Division. He's been the President of the International Law Commission. He's our top leading international law expert and has done tremendous amount of service to the country. Dr. Narendra Singh, please.
Thank you, Dr. Rao. Firstly, I would like to thank all the panelists for the wonderful presentations they have given. I would also like to thank Dr. P.S. Rao for the detailed overview of the Law Convention which he had given us. Now, as Dr. Rao mentioned, P.S. Rao mentioned, the focus of the G77 and developing countries during UNCLOS 3 was on deriving the maximum benefit from the discovery of the seabed manganese nodules or polymetallic nodules as they are now called. With this focus, it was to be expected that security issues such as the right of passage to territorial seas and issues of the marine scientific research, they did not get the necessary attention. And we have gray areas where different groups of countries have their own interpretations. While one set, the maritime powers, claim that they have the full freedom of navigation both through straits and also the freedom of carrying out the marine scientific research and even invoking the immunity of warships to say that any research carried out by warships is not subject to any claims of the coastal state of or the right to supervise or to authorize those research. So this is one area which was never settled for. And this problem, it is becoming more acute and it is being raised more frequently. Now, Dr. Sunil Agarwal had mentioned about the India's submission to the CLCS. He has properly highlighted how the claims have been submitted and how India's claim is still not decided. Well, when India's claim was submitted, based on the dates of submission, the estimate was that India's claim would come up only in around 2025, but it has come up a bit earlier. And of course, as he mentioned, the CLCS is a technical body which decides the submissions on technical credit. That is, whether a state has submitted adequate scientific data to support its claim for extending its continental shelf up to a certain limit. It cannot decide the boundaries between states. So that is a matter which has to be decided among the concerned states only, whether they do it bilaterally or by invoking one of the dispute settlement methods under the Convention. So this has to be very clear that the Commission is a purely technical. Where there are overlaps, the Commission can only say whether both countries would be entitled to have an extended shelf in that area. But to whom that shelf will belong is not for the Commission to say. Now the last presentation on the submarine cables, as Dr. Utpal had highlighted, submarine cables form the backbone of global communications. I know it's a lot of people think that we have satellites and we operate through satellites, but 95% of all the global telephone, internet, and all of the other electronic communications, they go through submarine cables. And that is why whenever you have a situation where you cannot access the internet properly or your internet is working very slow, it means that somewhere a submarine cable has been damaged. And here the priority is to restore those cables. How do you restore it in the minimum time possible. Here, there are many complaints on the submarine by companies which operate these submarine cables that they don't get the necessary permissions in time to come and to carry out the necessary repairs. Firstly, they have to find where the fault is, where the cable has been damaged, and then to repair that cable. And in the conferences which I have attended, the concern is always about repair. The Law of the Sea Convention is very clear that all countries, everyone has the right to lay submarine cables, but that is only in the maritime area. For landing a submarine cable in any country, the permission of that country is required and they must comply with the regulations. But the problems come at the time of repairs. Now, most countries, they have the security concerns, and which is why giving permission takes time. But I think in our age, we need to recognize that restoring these submarine cables, restoring communications itself is important for security. And so that these processes need to be expedited, so that without delay we can have the restoration of the submarine cables. Thank you, and sorry for taking that.
Thank you, Dr. Naren Singh. There was so we have to conclude by 12:30. Unless you, I would encourage you to ask questions at lunch time for many of the panelists. But one or two questions. That young lady, come on, first, quickly. Do you need a mic? I don't know if I can provide a mic to you, but speak louder. Yeah. Should we ask, would you like to answer that question as to what is the dispute resolution mechanism under the
Thank you for your difficult question. Yes, I think UNCLOS is just one of the public law, so it was concluded a long time ago, almost 40 years now. So it cannot easily update the newly advanced technology and methods and new tools. So that's a drawback of the international law. So we need to continue to revise the international law, which will be followed by the current situation and circumstances. But it's to revise some international law is quite difficult because we need to agree among all the delegations countries. So this is one of the loopholes which international law has having. So we understand what you are asking about that. For example, ILC or other international institutes are trying to how to revise, how to help some which will be accepted by all international community. So there's no any pure ways to solve the problems. Thank you for your questions.
Yeah, that set us thinking, and I will like quick last question. Only one question. I'm sorry. Yeah. quick, short question, quick.
Thank you for your question. Basically, it is not only India, it is most of these countries, they are yet to appreciate that protection of submarine cables is their own necessity. It is not the responsibility of the cable operators to ensure the security of this cable system. So therefore, India also are are showing a neglecting approach to cable system.
Okay, now we're just going to wind up. Please find them at the tea or this thing. I'll conclude. This has been a wonderful session. Thank you for our guests from Korea, and thank you from the National Maritime Foundation, Dr. Sunil Palrahag, great scintillating. What is said by us thinking, just like the young lady says, that we need to revise the UNCLOS, which is a dinosaur. And you know, if you see it, we have Wikipedia, you can keep on amending the pages. I would encourage somebody to put a draft and let everybody keep on amending it worldwide, so that it can keep getting amended for a period of 6 months or 1 year with everybody's comments and, you know, carrying it as annexures thereafter, so that we have a new UNCLOS in place with all these issues. You know, now law of the sea is so important. The submarine cables is the one. Gas pipelines. If you see the Russian Ukrainian conflict is because of access to Black Sea. It's the foundation of international law, and it continues to become more and more important. We have issues of fish stocks, we have issues of jurisdictions, deep sea mining. All of it is extremely important, and I think each one of you have highlighted and focused the issues, and we should carry this forward. And I'm grateful. I've been also given this opportunity to chair this session, and which is so dear to me. My great grandfather had 2 ships. He used to do business with Sumatra, Java, and Aden. So I carry his legacy by way of law of the sea. Thank you so much. It was lovely being here.
Welcome to parallel session on forced migration and statelessness. As you all know, forced migration means displaced migration, forced displacement, meaning thereby displacement caused due to persecution, general right violence, or serious violations of human rights. There are many issues related to forced migration and statelessness, to which panelists will turn later on. But this session consists of two parts. First part is online, and then other presentations will be offline. So it is better I should call Dr. M. Gandhi, Joint Secretary Retired, Ministry of External Affairs, to present keynote address for this technical session. Dr. Gandhi has served the Ministry of External Affairs, Legal Treaty Division, and he has, to his credit, many draft legislation related to human rights and other issues of international law. So, on behalf of the panelists, on behalf of all of you, and on behalf of my own, I welcome Dr. M. Gandhi to make his presentation. Since the time is very limited and we have to complete this session by 1:30, I will request Dr. Gandhi to present his views within 10 to 15 minutes.
Thank you very much, Mr. Chair. Am I audible to you? Yeah. I could see Ragini showing your hands as if you know it is I'm audible as well as visible to all of you. Thank you very much for the Indian Society of International Law for providing me an opportunity to share some thoughts on forced migration and statelessness. And you have very able speakers, including the chair himself, and he has written a lot of things on the refugee issues as well as migration. And I could see about 5 papers are going to be presented here. So I would like to give just a bird's eye view on what is forced migration and statelessness, because if I am giving every detailed aspect of it, the whole session will be completed, but that is not my intention. The forced migration is not a legal definition. Forced migration is a migratory movement which, although the drivers can be diverse, involve force, compulsion, or coercion. This term has been used to describe the movements of refugees, displaced persons, including those displaced by disasters and development projects, and in some instances, victims of trafficking. So asylum seekers and returnees, the returned refugees, also would come under the forced migration. The voluntary migration and forced migration all combined thing that have been happening all times in this world, right from the beginning of the world. If you see the sacred book, which is common, the Old Testament, the Christians as well as the Muslims, you can find migration and forced migration all through. So, although there is no legal definition for forced migration, and it explains the particular phenomena and all the connective units of the particular phenomena. And the forced migration, as per a recent data, the total number of people worldwide who are forced to flee their home due to conflicts, violence, fear of persecution, and human rights violation was 89.3 million. This is more than double the 42.7 million people who decade ago and the more since World War II. That means more conflicts, more disasters, more violence, more fear and persecution. That is a set of affairs. Now there are three agencies today, they are dealing with that, and most importantly the UNHCR and then the IMO. It is again the organization that is dealing with migration. But groundwork and the substantial work is done only by UNHCR on the refugee movements, displaced persons, asylum seekers, and statelessness because they have mandates. And the another institution is the NGO, that is International Displacement Monitoring Center. So what are all the causes for forced migration? And it was referred earlier by Professor, he is chairing the session about the conflict-induced, disaster-induced kind of a thing. So forced migration, as he rightly said that, it will be referred to as a displacement, involuntary displacement. In the World Bank document, you can find only involuntary displacement. And other documents you can find involuntary displacement or forced displacement. And in UNHCR and other areas, you can find that the usual, whatever the definitional terminologies which are all used there. So the forced migration would be a conflict-induced or disaster-induced displacement. The displacement induced by conflict is typically referred to as a cause as by humans, whereas natural causes typically underlying displacement caused by disasters. Where I would including a lot of things like famine, even the dam ousting, that all these things will be considered as the reason for the forced migration. Conflict may arise due to disputes over natural resources, and human activity may trigger natural disaster such as landslides. The first part I said that the disputes over natural resources is human activity, and the sub-Saharan Africa, the forced migration is due to this. The famine and environmental catastrophe could also belong to this category. Dam ousting, displacement of people by the development process can also be treated as persons which are involuntarily displaced. Then we have to see the statelessness. And there is a Convention on Refugees and Stateless Persons, Refugee Convention 51 and its 1967 protocol. Convention relating to the status of stateless persons 1954. Convention on the reduction of statelessness 1961. So here the refugee as well as the stateless persons we are talking about, and we are discussing something in a legal format. And while we are talking about the migration and enforced migration, our terminology is not strictly legal. Now who is stateless person? Article 101 says that stateless person means a person who is not considered as a national by any state under the operations of its law. And stateless refugees also a possibility, because we have been dealing with Rohingyas and Tibetan refugees, and refugees of the many kinds. You can say that they are stateless refugees. UNHCR has a mandate to deal with them. So what is important, because I think the holistic view should be taken, and the trend which connect with almost all aspects is only the human rights. So violation, there is a displacement, that is a forced displacement. What is important is that the violation of rights that are happening. Right to life, livelihood, and the right to fulfill the basic needs, and all these things are at stake. Therefore, the best approach to my mind is to just deal with the statelessness to human rights approach. Article 15 of UDHR, which says that everyone has the right to nationality. No one shall be arbitrarily deprived of his nationality or denied the right to change his nationality. If this being so, and international law basically, the nationality is the one that links the protective umbrella of a state on a particular region. So as international lawyers, we know how important this is. Stateless may occur in different circumstances. It occurs mainly due to conflict, nationality, and citizenship loss. And the Sri Lankan refugees and the refugees from Rohingya, and you can find that when both laws are applied, they become stateless because they don't have any documentation. You can just move out of that. And this when we say that this kind of a thing happens when there is a migration is irregular. The human rights people would say that it is irregular, but at the same time, if you see that state-centric interpretation, we would say that it is not irregular because they are illegal. So the irregular and illegal thing, which law that you invoke accordingly, it comes to be known. So the central obligation of 1951 Convention, core obligation contained in 51 Convention include those non-reforma, non-discrimination, non-penalization for illegal entry or stay, and the enjoyment of these rights. If this being the core, and you can see that how that the Refugee Convention and the Prohibition of Statelessness Convention that links. And in what are the important decisions, the more than Supreme Court, the high courts are very proactive on the refugee issue, because recently I have conducted a study. And where I come across a very interesting analysis made by the Patna High Court in Karan Gupta versus State Election Commission. This was by the two judges bench that observed that the UNHCR 1954 Convention relating to the status of stateless persons and the 61 Convention on the reduction of statelessness are presently the leading multilateral treaties about the prevention and reduction of statelessness. This is fine, the first sentence. The second sentence is, it is in fact the very idea how the court is approaching this, started approaching this thing. Both conventions simply confirm the prevailing international law that imposes duty on states to prevent and reduce statelessness. Although India is not a signatory to either statelessness convention, this duty to prevent statelessness has been consolidated in several other international legal instruments to which India is a party. So the idea is that if India is not necessarily a party to the Convention on Refugees or the status of statelessness persons convention, and the court finds that you have to consolidately take what the obligation that is available, that is existing under international law for a state. On that basis, there could be a compulsion to reduce the statelessness. Then, whatever is there finally, when a refugee problem becomes a refugee, the asylum seekers and statelessness, all these things are intermixed because the terminologies are used to identify the separate legal region codes that is available. But a general statement, if you want to make it, that the durable solution should be a solution finally that has to come up to deal with all the problems, including the refugee problem. So the promotion of durable solution by UNHCR, which is the core of mandate, and that includes voluntary repatriation, local integration, and resettlements. And permanent resettlement is the most desirable solution. And local integration is also happening with the help of NGOs, microfinance schemes, vocational training, and community mobilization program. And resettlement in a third country as part of burden share. That I did not go in detail because the problem in Syria is half of the population or they are the migrants, the ports migrants. And the same thing happened in Libya, same thing happened in Afghanistan, same thing happened in Rwanda, and same thing happened in many other countries in sub-Saharan Africa. The only thing now, it is in fact now the is looking very keenly is that Ukrainian-Russian war. So this is the first time they are, tasting how it would be, how to manage it. And rest of the time, saw in sub-Saharan Africa. And if you see that in the statistics, you can find that the Asia is 31% of the migration, the forced migration that happens only in Asia. 30% in Europe, 10% in the US, and rest of the countries. So the resettlement in a third country as part of burden sharing is always dependent on this. And for this purpose, there is a complementary migration option also. And the complementary migration option is that the family-oriented migration avenues and lobby group amnesties, enhanced cooperation with the regional and national agencies that drive labor issues, including employer and professional groups, to explore labor migration options for refugees, and continue to raise awareness about the specific protection needs and rights of refugees while providing access to migrant framework. And self-reliance also can be encouraged during the asylum procedures prior to recognition of refugee status and pending the identification of a durable solution. The scope of benefits and access also can be expanded when the person is recognized as a refugee or asylum seeker and it is pending, but at the same time a temporary status is given. And the voluntary repatriation also another method by which the forced migration and that will come into an end. And it requires appropriate measures to ensure that any choice regarding return made by refugees voluntary, free from coercion, based on objective information. Support for the return of the refugees to contributions of physical, legal and material safety with full restoration of national protection as the ultimate end that ensures that return takes place in safety and with dignity and that it is sustainable. So there are some achievements in finding, the durable solution, and one that has happened in Mauritania in 2010, Afghanistan 2008, Kazakhstan, Great Lake region, and the internally displaced persons also will come under this category, and this has happened in 2010 in Sri Lanka. So the inclusion of refugees in national system is also important. Wherever, if you do not know the refugees are recognized or not, the social safety net can be provided, education can be provided to refugee children, and economic and financial inclusion that includes insurance, and all these things also can be provided. And UNHCR is working towards the reduction of statelessness, and it assists the governments in drafting the national legislation and enacting new nationality laws and helping to citizenship or other IDs from government to status, connecting with parliament entities. It's all laudable work, but what is important is that holistically every organization should support this, and UNHCR is known as holding cooperation with international organizations and funds and programs, UNHCR Wellbound, UNHCR and UNDP, NGOs and organizations. I think the matter is very clear now because more in the policy realm, more needed is the finance, whether it is the voluntary finance or international finance, and more importantly, what is important for even if it is a non-voluntary kind of a migration that takes place, and we have to respect the
I think, Dr. Gandhi, I think you should conclude. We just.
I have concluded. Thank you very much.
very good afternoon, everybody. And to begin with, I would like to thank ISI for putting up this very important conference. And so I would begin with thanking ISI to put together this important conference on varied aspects of international law, which are extremely important in today's context, and they've always been important and will continue to be important. And from our perspective, very important is the topic of refugees and the issue of statelessness. And as I go and I continue with my presentation, I'm sure all of you will also appreciate why at this point of the world, at this point of time, this topic has become all the more pertinent, because it's not an issue that only UNHCR or states have to deal with it. By the sheer magnitude of the issue that as a humanity we are dealing with it, it is to some extent the responsibility of each one of us to see how best we can address the situation. I'm not sure whether we'll be able to resolve it, but definitely each one of us has a role, and that's why the topic's name is also a whole of society approach, because that's what as UNHCR we say. But just to give a bit of an overview, since I represent UNHCR, which is the UN's refugee agency, the agency was created in 1950, and the mandate was given by initially the General Assembly gave a mandate to the organization to deal with the forced displacement or the refugee crisis that had arisen because of the World War II. And the whole idea, the world, UN is basically all the governments of the world. It's not an entity that has come from anywhere else. The world thought that in 3 years this issue will be resolved. There won't be any need to have this organization, and then we will probably wind. But unfortunately, 72 years later, I'm standing here in front of you, and the organization still exists with over 18,000 staff operating in 137 countries and territories in the world. And what does that tell us? That really tells us what has happened to the global order, what has happened to the conflicts. Maybe some conflicts got resolved, but most of them have still lingered on. And the forced displacement, Professor Gandhi already mentioned that we have over 84 million. Actually, we have crossed, it's reached 103 million now, because the statistics also take some time in updating. And the displacement that there is right now in the world is much way beyond what had happened even because of World War. So it is in fact a sad state of affairs that the world is in, that I am still representing here in UNHCR 70 years after, when originally the world had thought we will probably not meet this organization. And why was this organization created? I think it's very important to understand, because there's a lot of rhetoric sometimes you may hear which is directly linked to the topic, since we're talking about international law, is that UNHCR was created at the statute, 1950 statute is what created UNHCR. Then we had the 1951 convention, which Professor Gandhi also talked about, the convention related to the status of refugees, then its protocol, which was there in 1967. And UNHCR was given a primary responsibility to provide international protection and humanitarian assistance to refugees. And why do we call it international protection? Because it all comes within a broader framework of international law. Because by definition, refugees are people who had to flee from their countries. So it's always displacement. They had to run away from their countries because they had a fear of being persecuted on account of race, religion, nationality, political opinion, membership of a social group. And most importantly, they lose their state protection. So when people flee, they cross borders, they go to another country, obviously they lose their own national protection. And that is why we say it's international protection, and the entire broad framework that first kicks in is international law, the protections under international law, obviously complemented by human rights law, and then you have various, and also jurisprudence, then domestic law. But Our main mandate to work was with refugees, and then over a period of time, returnees, stateless persons also, which Professor Gandhi also mentioned. Then we had the 1961 and 64 convention, and stateless persons also there are, because the word itself is negative. Stateless are people who are not considered as citizens by any country under operation of the law. So often the figures of how many people would be stateless in the world is also not there, because nobody counts. There are invisible people, and they may be displaced, they may not be displaced. Refugees are always displaced, they always cross an international border. A person is never a refugee in his or her own country. This is again a big legal flaw that is often noticed in a lot of writings in media, which creates a lot of confusion. People who are refugees are called migrants, migrants may be called refugees, and when we intermix in these legal concepts, the response of the state, the society, the communities may be different, because refugees under international law are specially protected. Migrants also need to be treated with, their human rights need to be respected, treated with dignity. But the specific protections that law guarantees refugees may not necessarily be available to others. So sometimes this intermixing of terminologies may be by design or it may be by default. So building on that awareness is also extremely important. Again, stateless persons may not be necessarily displaced. People may be living in the same land for generations, for years, but not considered citizens. A classic example very close to our region is the Rohingya. The Rohingya in Myanmar, while they are still in Myanmar, they're stateless, or they could be displaced within the country, which we could refer to as internally displaced persons or IDPs. But when they are forced to cross an international border, whether they are in Bangladesh, whether they are in India, Malaysia, wherever they are, they also become refugees, because they meet the internationally accepted definition of the refugee. So we can have stateless refugees also, we could have stateless IDPs, and we could have just people stateless, and because of that legal lacuna and vacuum, unfortunately, they don't have citizenships, which then impact their access to legal, social, and political rights. So stateless, working with refugees, stateless, returnees is a mandate that UNHCR has, but in certain circumstances, we may also be asked to work with the internally displaced persons. So since IDPs are always, maybe mostly the citizens of their country, these are only specific times when UNHCR may work with a refugee. And how do we work? We work together, because we are a UN agency, is to support states, because ultimately it's the primary responsibility of the states. The countries of origin, ideally the conditions should not be there that people are forced to flee, but when they are forced to flee, is the responsibility of the states, very clearly articulated in the human rights law, in international refugee law, customary law, main pillar protection also given in the 1951 convention. But 1951 convention is not the only convention that articulates the rights and protections that refugees should have. So as UNHCR, primarily we work with states also to ensure rights of refugees, IDPs, stateless persons, returnees, primarily that they have access to territory, they are protected, they have access to basic protection. In many situations, we also conduct what we call refugee status determination. We advocate for, we conduct advocacy across themes, most importantly, to ensure everything that the refugees, the rights they have access to those rights, and wherever possible, they are also possibility of solution, whether it's local integration. Now, most importantly, since we're talking and the whole discussion is in the context of laws, refugee rights are also human rights. There are a lot of, the refugee protection, as we call, it is not created, it is a part of international law. We have the 1951 convention, we have UDHR, but also we have ICCPR, we have we also look at the constitutions of the country, the jurisprudence the courts may have created. There are also specific protection for children in CRC, the protections provided in CEDAW. And often when you would have heard the discourse that sometimes often questioning UNHCR's mandate to work with UNHCR, because the country may say, I have not signed the 1951 convention. But the UNHCR was given a mandate, but not only by the 51 Convention. It just builds on what was originally given in the 1950 statute. There are numerous executive committee resolutions. There are so many resolutions that have created UNHCR and the mandate of UNHCR. So when any country sort of says that what UNHCR does or what UNHCR does is not binding on me because I have not signed the 51 Convention. We all here students, I won't say masters of international law, no, nobody can be. We all here students of international law, that's our interest, that's why we are here. No state can question a mandate that has been already provided by a UN agency by saying I have not signed one particular document because that mandate has already been given. That mandate cannot be questioned. And at the same time, it's not only the 51 Convention as I mentioned, but there's also, again, a lot of protections, especially the right to non-refoulement, which is a cornerstone and pillar of refugee protection, which means a refugee cannot and should not be sent back to the country from where they have fled because that's where the right to life is at risk. May be enshrined in 1951 Convention, but it is also part of basic human rights. It's also part of the right to life. It's also part of what the Convention Against Torture says and many other conventions. So the mere argument that we may not have a signatory to the 51 Convention does not do away with the obligations, including the fact that principle of non-refoulement is a customary international law. It's well-settled principle in law. And no state can say that customary international law is non-binding. I'm sure there are enough experts here who can also support this argument. So irrespective of a state being signatory to the 51 Convention or not, this basic non-refoulement principle is binding. So while I may say that international law is very clear on this position, but that does not mean there are no challenges in the world. Unfortunately, over the last few years, we have also seen that while there is an increasing conflicts, there are increasingly the number of people who are getting displaced is increasing, challenges are also increasing. So instead of giving refuge to those who are fleeing the country because of no fault of theirs, because they just happen to be in that situation, we have seen people being rejected at land borders, rejected in sea, boats getting drowned, people getting killed, violent pushbacks, societies and communities not being welcoming, refugees not being included, increasingly restricted laws, detention, xenophobic rhetoric. These all challenges across the globe are also increasing. And as UNHCR, we always advocate that humanitarian considerations and national considerations complement each other. They're not against each other. Each state should be rightly worried about national interests, national security imperatives, but humanitarian imperatives and security imperatives can go together, they can complement each other. Good management, whether it is border management, whether it's asylum management, does not preclude that asylum claims cannot be heard in a fair and efficient manner, and those who need international protection get it, and who do not deserve international protection do not get it. Because if states are not protected, if local host communities are not protected, refugees will also not be protected. So national interests, national security, extremely important, but not at the cost of humanitarian considerations, because even refugees have a right to life. And most constitutions, most domestic laws also guarantee right to life, including ourselves. We have a vibrant judiciary, a vibrant dynamic constitution where it is now a well-settled principle of law that Article 21 applies to everyone. It may have been subject matter of a lot of court decisions earlier, whether it was a Khudiram Chakma case, whether it was a Louis Dede case, but now it's undisputable, nobody questions. Article 21 applies to any person. That's the language of the Constitution. It doesn't say citizen, it says person. And definitely the drafters would have put some kind of, and even our courts have said that. Building on to what Professor Gandhi, he referred to a judgment of the Patna High Court, we have a very vibrant judiciary. I mean, we had the Vishaka judgment, which created the law for sexual harassment. But when I advocate for refugee law as a lawyer, I say Vishaka judgment is the best judgment to advocate for the rights of refugees. But what does Vishaka judgment say? Basically, Vishaka ratio says when you don't have a domestic law, when you want to look at issues of human rights and you want to expand them, look at what are international conventions and treaties. Maybe that was in the context of CEDAW, but here, when we're talking about refugees, again the argument that India does not have a domestic law actually is not, in my judgment, is not 100% legally sound judgment, because we do have jurisprudence, we have international law, we have customary international law, and most important, we have the ratio of Vishaka. Leave any other judgment. I have a compilation of 300 pages of right from magistrate courts to Supreme Court. Only see Vishaka judgment. Use that logic. There is a gap in domestic law. So if there is a gap, international law will prevail, because this is an issue of human rights. And what is international law? Look at the 1951 convention. Look at what ICCPR says. Look at one. So this is an argument that probably needs to be supported by people who are advocating in Supreme Court. And Mr. Rao, I'm looking at you. Probably you need to help me articulate this view better in Supreme Court, because in Supreme Court we have a lot of pending cases on the issue of refugees, including whether right to anybody who enters irregularly in the country can be considered as a refugee, whether non-refoulement is binding on India. And in my humble opinion, based on little knowledge I have because of my work on refugees, on international law, I'm sitting in front of me, Dr. Narendra Singh. I cannot say I am an expert, but I think this logic should be widely articulated, that if you have a statute, you cannot say that what UNHCR is doing is not binding. That's a flawed, in my opinion, argument in international law. So I'm really looking up to you to help that refugee protection, and jurisprudence is not only law. Jurisprudence also is what the courts have said, and that cannot be ignored. So I'll just take 2 minutes. That's why, coming back to my earlier submission, that refugee law and human rights law, domestic law, they all go hand in glove. And why I'm saying it's extremely important for each one of us to see what we can do is the numbers. The numbers, 82.4 million, is not a small number that any organization or any state can be expected to deal with it. And also, when a lot more people, about 86% are posted in developing countries, and 76% of the people displaced globally are only from 6 countries, and some in our neighborhood, which is including Afghanistan and Myanmar. In fact, Ukraine changed the whole ballgame. It's been the fastest displacement, even more faster than the world war. And when we, as UNHCR, when we talk about broader protection, what we talk about is broader access to rights, whether these are rights of physical safety or socio-economic rights. And because of the scale of displacement and the challenges which have increased, UNHCR and the world together, and the UN has also come up with, all the states together have come with the Global Compact of Refugees to complement the existing international framework, which also advocates for supporting the host states, communities in a much better way, because the challenges have increased. And it really advocates bringing in the development angle to the humanitarian angle, and the role of everybody, that each one have, because we know we have a solution deficit. We have 2 challenges, but there is a big solution deficit. And that's why it's a whole of society approach. Anybody, anywhere, whether it's a school teacher, whether it's a lawyer, it is an academician, everybody has a role to play. A teacher, when they allow a refugee child to be enrolled in a school, are playing their role. And advocate, when they argue, not necessarily only in court, but to help somebody access rights, are doing their part in this broader refugee framework. And it's a matter of equitable responsibility sharing, so that there is a multi-stakeholder partnership. We broaden the support base, and only then can some of these challenges be addressed. I'm sure not minimized, but when you have 104 million people globally displaced in the world, I'm sure even a tiny individual effort made by one individual is going to make some impact. Thank you very much. And sorry for rushing because we also have to respect the time that other speakers need. Thank you.
Very good afternoon to the respected chair, Professor B.C. Nirmal sir, respected dignitaries sitting with us, dear presenters and attendees. I, Mohammad Sufyan Khan, student of LLM, would be presenting on the topic Climate Crisis, Disaster Displacement and State-led Person, an alarm that fails to ring the bell. As the author, Dr. Mirza sir, couldn't make his way to be here due to some unavoidable circumstances, I, on behalf of him, sincerely apologize to the chair. In today's presentation, I would be dealing the issues and challenges due to climate change, role of international institutions and international human rights law, India's policies and framework for displacement due to climate change, and the judicial response, followed by the concluding remark. Before starting, I would like to quote the words of Ms. Arundhati Roy from his work, The Greater Common Goods, that the millions of displaced people in India are nothing but refugees of an unacknowledged war. On an average, one person is displaced every second as a result of disaster. In fact, disasters now account for the largest number of displaced people every year, which is more than any violence or conflict. These disasters lead to internal displacement, or they might be forced to leave the international borders. Climate change has a grave impact on the entire humanity, especially the subaltern class of the third world countries. As per the report of Global Report on Internal Displacement 2021, approx 23 million people are displaced. Now coming on to the issues and challenges of displacement due to climate change. The first issue is the economic loss. Wherever there would be displacement due to climate change or any other issue, that gives the economic impact onto the both displaced person as well as the host communities. As the displaced person are not well versed and they lack resources, they lack skills to get employed to any other place, so that leads to poverty. Further, the host communities where they are going to reside, where they were displaced, they were forced to displace, they have lack of resources. Now they have to share those resources with the person, with the people, the communities which are coming to reside there. So the economic economic loss is one of the basic issue due to the displacement. The second comes the social inequality. As the displaced people have a limited number of resources, limited number of access to health, education and other social services, they face inequality. Further, they may be subjected to discrimination in the host communities because they are not from that particular place, they were displaced, they were forced to reside at that place. Now the third issue which is very prevalent, that is legal status. So as the displaced people have limited access to legal status of displaced people in their host countries, which make them not only vulnerable, but they also are exploited and abused wherever they go. Further, there is also a struggle in implementation of legal frameworks to protect the rights and rights of those displaced people. The last issue, that is loss of cultural heritage.
whenever the displacement occurs, what happens is that the displaced people are forced to leave behind their traditional lands, customs and practices, which lead to the erosion of their cultural identity. Now coming on to the role of international institutions and international human rights law. So as we all know that international law provides legal framework for the protection of displaced people as well as for the prevention of displacement. So the first agency is United Nations Framework Conventions on Climate Change, which basically provides framework to guide global actions on to reduce greenhouse gas emissions. Further, that also calls for action to reduce the impacts of climate change, including the displacement. So UNFCCC is continuously working to reduce, working for the reduction of climate change to reduce the carbon cycle. Further, the second and most important agency is the International Organization for Migration, and which is leading international organization in addressing displacement caused by climate change. Now the third one is United Nations Guiding Principles on International Displacement, which was adopted in 1998. In addition to it, there are other number of international laws and agreements that address displacement caused by climate change, and that are United Nations Convention on the Law of the Sea, 1982, the International Covenant on Economic, Social and Cultural Rights, 1966, and the International Covenant on Civil and Political Rights. Coming on to the Indian policies and framework for displaced person, the first act which is very prevalent is Disaster Management Act 2025, which basically provides for the establishment of management authorities at the national level, state level and the district level. Apart from this, it also provides for the formulation of disaster management plans, for example, the setting up of early warning system and the relief camps for the affected person. Further, there is National Disaster Management Plan 2016, which provides framework for the management of disasters, including those caused by climate change. The last one is the NDRF, which we all know, which is a specialized force created to respond to disaster caused by climate change. It is also responsible for providing relief and rescue operations. So this is the chart which I have mentioned, that to how to recover to the disaster, that is mitigation and prevention, then preparedness, response and recovery. Further, as we all know that Indian judiciary has taken proactive role in addressing the issues, addressing the rights of the disaster displaced, the person displaced, the community displaced by the due to the disaster. The very first case, the leading case, that was Narmada Bachao Andolan versus Union of India, in which the Honorable Supreme Court has especially reiterated. Just a second, sir. I would be taking two case laws and I will find. So where the Honorable Supreme Court has reiterated that rehabilitation is not only about providing just food, cloth or shelter. It is also about extending support to rebuild livelihood by ensuring their necessary amenities of life. Concluding myself, that is the climate change is the major crisis of present scenario, which and disaster displacement is one of the most devastating consequences of the same. Though the entire populations are affected by the disaster displacement, but the vulnerable sections of the society are the most affected person. Further, refugees, internally displaced people and the stateless are on the front lines of this issue due to the displacement. And there is the need of the legislature and executive to work efficiently and effectively for the same. And judiciary can also ensure the government to take preventive actions to prevent this displacement. Further, lastly, those who are displaced should be provided with adequate compensations and assistance, and necessary steps should be taken to prevent further displacement. Thank you.
Friends, I wanted to give the participants as much time as possible, but due to time constraints it's not possible, and I feel very much sorry that I am unable to give them time. to express their views on the subject they have decided for presentation here. So I will now request you just confine yourself to the issues you have raised in your paper and what are your findings. Then develop your paper and send your paper to ISIL yearbook of humanitarian and refugee law. So that may be a good avenue. Yes.
Good afternoon, respected Chair, my fellow panelists, dignitaries, and everyone in the audience. As the Chair has requested, I will keep my presentation as brief as possible, however, elucidating my major points. So I am Kane Lamar, and the topic of my paper is Forced Migration, the Case of Environmental Migrants. As we know, migration is an area which is very much discussed and in practically all fields. In international law itself, the founding scholars like Grotius, Pufendorf, Vittoria, all have engaged with the subject matter of migration. In the law and policy domain, generally speaking, when we talk of migration, we normally discuss about migrant rights, and on the other side, about the issues that emanate in host countries, like security issues, etc. So this is normally where we confine ourselves with respect to law and policy discussions. Migration has been classified in numerous ways, and this classification of migration has, to a large extent, informed the law and policy decisions. So the way you classify a particular individual, maybe economic migrant or refugee, then also ensures what kind of legal obligations or rights they have. So classification is something very important. One of the major classifications that has been done in the field of migration has been this classical and traditional classification of forced migration and voluntary migration. In fact, one of the themes of this present conference itself is forced migration. However, in my paper, what I tried to elucidate with the example of the environmental migrants is that these two binary definitions of voluntary and forced migration at times does not allow us to completely understand the complexities of the phenomenon of migration itself. So if we look at the understanding of forced and voluntary, we've already, my fellow panelist, Dr. Gandhi, also has already defined what you understand by forced migration, so I'm not going to go there. But what I would like to draw your attention to is that when we speak of the word voluntary or forced, most of the time it is considered to be very self-explanatory. So when we say voluntary, you're basically saying we're going to migrate because we have a choice. But how do you understand this volition? Do you mean to say that I am migrating because I have the choice, or you're choosing out of certain options that are already there? So then do you term that to be truly voluntary, or is there some amount of forced also present in that? So this can be very specifically looked at in the area of environmental migrants. Why do I say that? So I think one of the panelists already spoke about the idea that when we talk about displacements due to natural hazards, etc., we say that it's forced migration. So we would assume that such type of individuals would come under the category of forced migrants. However, when we talk about environmental factors, you have issues of fast onset hazards, you have issues of slow onset hazards. Now, if someone is moving out of their homeland because of the slowly degrading environmental situation there, would you then still call it voluntary migration, or would it then be termed as forced migration? So therefore, you have a blurring of lines between voluntary and forced. Now, I'm not going to go much in detail at the moment. I'm just going to come to my main point, saying the challenge here then becomes, because we like it or not, we are labeling individuals here. We are labeling someone as a migrant, we're labeling someone as a refugee. In migrants also, we are saying, is it an economic migrant, is it an irregular migrant, etc. So now when you're having these labels, and the idea whether the nature of whether the migration was forced or voluntary makes a very important impact on that migrant as to what rights will be available to them, what obligations does the state has for them. So therefore, understanding the nature of migration becomes very important. And my argument basically is that this traditional binary of voluntary and forced migration needs to be reconceptualized, especially in terms of the environmental migrants, because we need to bear in mind environmental migrants still now, under international law, have not been recognized as a category who can have rights associated under migration law. Of course, as under the human rights laws, etc., we can ask that, as a human being, you will be having those rights. But as a specific category, they are yet to be recognized. Therefore, that is primarily my argument for this. And thank you so much.
Very good.
Hello everyone. I will be presenting on behalf of Dr. Sudhir Verma and myself on reading Third World International Law in the Power Politics associated with recognition and the duty to protect as a response to forced migration in international law. I will begin by emphasizing the influence of imperial project on the very foundations of the international law. It is observed that the histories of the forced migration as well as the histories of forced migration runs parallel to the colonial histories of the world. Events of forced migrations are largely based on the political and ethnic grounds, which generally either emerge is a consequence of failed decolonization exercise or the hovering political pressures. It is among these political pressures and these global politics that the politics of non-recognition takes place. Therefore, it is utmost necessary to address the power politics surrounding the law of recognition. The examples of this colonized history supported by the power politics and widespread imperialism can be seen in the history of the forced migration, in that of the case of Kashmir, Donbass, and as well as Palestine. We need to realize that the exigencies of human rights violations and the want for humanity is much larger and more required for a forced migrant originating from a non-recognized state than a recognized state. There is a lot of politics surrounding the recognition, and the politics of recognition counters the territorial integrity as well as the political independence of these areas and poses questions to the legal personalities of these areas and raises multiple jurisdictional questions with respect to the determination of the rights of the peoples living in these areas. Now, these disturbances and conflicts in the current world order has been a result of the continued colonized histories and the governance and the subsequent marginalization, which the third world which the authors of the third world approaches to international law have immensely elaborated and reflected on. But to keep it brief, I would rather go to the solutions that I would like to propose to resolve the current issue. And the solutions of the problem, which I'll be highlighting, can be in threefold. The first is that there needs to be a consensus on the will to protect the rights of the forced migrants. And I believe the international community in this sense has made progress with the adoption of Global Compact for Safe, Orderly, Regular Migration 2018, which affirms the state's responsibility to protect and also affirms the state's duty under the principles of non-regression and non-determination. Other efforts in this direction include the State for Rights, Stand Up for Migrants campaign, as well as multiple development of various guides and handbooks to assist the international governments throughout the globe. Second, and the most important, is to entail the assistance of through the global governance to provide a state-based solution. And the task here is to inherit the utilization of new havens approaches of international law to facilitate and make policy changes and policy developments in concerning migrants' rights, regionally, domestically, as well as internationally. Now, to provide an individual-based solution, we all need to look at the human rights violations from a prism of humanity, justice, and an overarching principle of solidarity. And the three principles, therefore, that I mentioned, the humanity as well as justice and solidarity, establish a duty to protect the forced migrants on the mightier nation, regardless of the policy consideration. Third, lastly, the end goal is to free the post-colonial realities from the enslavement of all the colonial origins and entail an inquiry and a new mechanism to read international law. The need is to counter the transnational politics of the globalized world. The need is to rethink and reimagine international law from the traditional concepts of the traditional sources. And herein, I believe that integrated Marxist approaches to international law can provide a lens to secure the desired humanity in this context. This is also essential because integrated Marxist approaches to international law draws from post-colonial theory as well as from social feminist theories, which is extremely essential to reflect the realities of the global South, a global South which is wherein the majority of forced migration concerns are rooted. This in turn, I think, will lead to the larger inclusiveness from within the narrative of protection under the international law, having a potential and will enable the discipline to rethink itself from within, as well as reworking like this would initiate a process of entailing dynamism in international law. Lastly, to conclude, I would leave the audience to reflect on this question that is left to be answered by all of us, like what are the continuing efforts that are supposed to be followed of this policy of inclusion, and till what extent we as an international community is ready to neglect the human dignity of the marginalized forced migrants originating majorly from the global South. Thank you.
Made their points of view within very time limit, specific time limit. I was asked to wind up this session by 1:30, but it is now 1:40. So, if one question may be taken, and I think if you want to seek any information or clarification, Ms. Ragini Kapoor is from that agency which has been working for refugees, stateless persons and internally displaced persons. So one question, just one question, two questions, then one line question, one liner. Yes.
very difficult for me to have a clear answer on it. In the context of the economic crisis, first to just a bit of an explanation. In the Indian context, we have different refugee groups which are sometimes treated differently because obviously we don't have a predictable refugee domestic law or policy. With the Sri Lankan refugees, they have been they're more directly dealt by the government of India in terms of having been also have camps for them in Tamil Nadu. And even the recent arrivals who may have arrived in India, there are probably over 300 of them because of economic reasons. But the fact is they've all been Sri Lankan Tamils, many of whom actually were refugees who had repatriated to Sri Lanka, and also of generally the development deficit and the problems that the ethnic Tamils still may have in Sri Lanka despite their return. When they have arrived again, the government of Tamil Nadu has allowed them to go back to the Mandapam camps to the best of our understanding, and they are again living back with the communities and often their relatives. They may traditionally not 100% meet the refugee definition. The driver may be more economic, but the fact that the ethnic element is always there is also probably distinct from the response from the system here in India and treating them similarly as. Now coming back to your question, again, the language, how people are treated, how it always changes, it evolves at what level, stage, what changes. Like earlier, people who survived any gender-based violence, they were all considered as victims. But now in the human rights language, everybody is a survivor. But when if it is trafficking, it's never a survivor, it's always a victim. Because you're not survivor, there's this trafficking is so exploitative that you're always a victim. So I'm sure the definitions will evolve, like in the refugee context, what is persecution? 10 years back was different, how persecution is interpreted is completely different. Persecution because of gender is not a ground even in the refugee definition. But in the membership of a social group, interpreted now, morality, what these norm will evolve, which debatable question or a matter of time. And also coming back to your question, sir, in the Ukrainian crisis, it's actually a very good model, the way it has been treated, and probably a good model for states to replicate from a refugee perspective. Even in the same region, unfortunately, the other groups may not have been treated similarly. But Ukrainians, when they arrived in the entire Europe, most of the states have been very, very welcoming. They have opened their borders, they have allowed them access, and what we call is there is a temporary protection regime for them. They have different schemes. So it is probably a good model and hopefully the states who are hosting the Ukrainian refugees and others who may not be hosting Ukrainians, who are hosting all other refugees, also look at it that despite the huge numbers, when you have open borders, when you have systems in place, and most importantly, when there is a political will to address the situation, it does take time. Such refugee influxes also can be dealt in a more humane way, and maybe it's a model that probably may inform other models. Let's hope so.
Thank you all for making this session very useful and productive. I would like to make just one submission that as a lawyer we are too much technical in understanding the problem of forced migration. The problem should be viewed in a broader perspective. And if you do that, then you will find that the issues of migration are related with border and territorialization. Hostility to migration has now become a point for winning election. Angela Merkel was supporter of refugees. She lost the election, and those who are hostile to migrants from Africa, they are winning election. So this is also being used for carrying out a populist agenda. And when populist agenda is pursued by the government, they never care for your human rights, a strong resolution, and there is also a thinking in many countries that why we should feel bound by human rights treaties obligations. Those treaties were signed and ratified by our earlier predecessors. We should not, everything is Changasi. And when everything is Changasi, who cares? Just see what has been the role of many governments in human rights movement. In my paper on Rohingya protection, I said, we say these rules have become now part of fashionable international law and therefore we are binding. Government says we are not bound by it. When the matter is brought before the Supreme Court and people like us expect the Supreme Court to give its ruling on the issue of non-refoulement, then no answer is given. Rather, the Supreme Court becomes technical and decides the case on the basis of existing foreign laws, saying that they should be deported only in accordance with the provisions of law. So I'm not just talking about one country or another country. I told yesterday also, I am telling you today also, we will have to have a rethink on all aspects of international. Because shame, and that is the idea of human rights. If we say that we don't care for public opinion, world public opinion, then what can you do? You may talk about the Fuji Convention, protocol, this, compact, others, but then who cares? Nobody cares for it. So let us be realistic, and I will request Dr. Hegde and others, please think over this and let us come out with an alternative framework for addressing the issues that we are facing today. Thank you very much.
Request you all to kindly join for the lunch. On second floor.
afternoon. We start today's afternoon session on climate change and sustainable development. I think this is an extremely important and contemporary topic, and it has had an impact on the economies of the world at large. Yes. The word sustainable development not only finds mention in international treaties, but it has become a way of life for a number of countries with national environmental policies reflect needs for sustainable development. It's an important topic, and combined in that we have climate change, and it is one of those areas where India has taken the lead by a number of initiatives, not only by declaring that it shall have net zero emissions by the year 2070, and a number of renewable energy programs, support to the CDRI, support to the International Solar Alliance, and a number of other initiatives, especially starting after the Paris Agreement. Without wasting much time, I would now like to hand over the first topic to Dr. Anwar Sahib.
Good afternoon, everyone. And as Sir has already said, it's extremely important. I completely agree that it is extremely important. But attendance is very thin. But nevertheless, it does not diminish the importance of the topic. As Sir has already said that it affects economic development. This is the truth. So before dwelling upon at length on the topic which I have assigned for myself, that is Indus water treaty. So I would like to say a few things on the front of climate change specifically. That there are three broad contours we can see regarding climate change. That Paris Agreement envisages nationally determined contributions are the basis of negotiation and the basis of expectation that we would be able to restrict global average temperature to 2 degrees Celsius, below 2 degrees Celsius as compared to pre-industrial levels. You find that there are a number of litigations coming up in the area of climate change, in national jurisdictions as well as before international courts and tribunals also. Yesterday also there is 2 days back, there is a Inter-American Court of Human Rights judgment on climate change. I have yet to go through the entire list. So, climate change litigations are coming up. This is second scene. Third scene, we find that the emission trading is expanding because Paris Agreement leaves the floor of emission trading for all countries, including developing countries. Earlier, it was only green development mechanism, that was where developing countries can enter into carbon market. But now it is open for the three broad developments that we see across the globe on the front of climate change. So, with these general remarks, so today's topic that climate change and Indus water and water treaty in South Asia. So there is no doubt that the climate change is going to affect fresh water. So which is a critical resource for many countries, for many purposes, and it has no substitute as regards drinking and agriculture. Isn't it? Fresh water is very less, it is thinning, and I am going to say a few things in the context of water treaty. So there is international water course agreement between India and Pakistan, though they are hostile neighbors, that the Indus Water Treaty 1960. The most important feature of the treaty is allocation of rivers, not allocation of water. This is something very serious, unique thing in the history. It is because of historical contingency, partition on the ground of religion, bloodshed. So this historical contingency was the basis that the leaders were of the view that we have to agree. Allocation of rivers. Eastern rivers went to India's side, Satluj, Ravi, Byas, and western rivers, Jhelum, Indus, Jhelum, Chenab, to Pakistan's side. Isn't it? And the thrust of the treaty is optimal utilization. There is no explicit provisions on environmental protection, not to cause significant harm. Equitable and reasonable utilization, these are the two important principles that govern transboundary shared water course is not there in the treaty, isn't it? So these are the important provisions that should serve the purpose of revisiting the treaty. In the context of climate change, that is going to result in fluctuation in the availability of water, in the Indus water, in the water body. Okay, there is going to be variation in flow, there is going to be variation in availability of water as a result of melting of snowpack, as a result of extreme precipitation, low precipitation. So we are going to find lot of variation in the availability of the water. Okay. So this alteration in the flow of the water, how we will be able to adjust it? There is need of adjustment of the treaty with respect to these situations which are going to come up. Isn't it? Optimal utilization of water, optimal utilization approach and the partition approach is quite unfriendly to these two principles. Not to cause significant harm, equal and reasonable utilization. You say that these are your waters, these are my waters, but when the availability will fluctuate, then how you are going to deal with it? So this needs to be addressed in the Indus Water Treaty. Okay. So there is in Indus Water Treaty there is permanent Indus Water Commission is there, but that doesn't have independent functioning, as it cannot regulate the entire water. It doesn't have the power to jointly manage, to see the entire river as one basin. Since it's a shared river water, transboundary river water shared, so there is a clear interdependence in these water bodies, and this has to be treated as one unit. Without treating as one unit, it is very difficult to find a solution, to find a way out when there will be consequences of climate change on these water bodies. We have seen flood in Pakistan in 2022, 2020. Okay, and we have to find that how we will be dealing with this situation. There are many water treaty agreements that have in course of time, after seeing that cloud desertification, they have incorporated escape clause in their treaty. And one of the examples is 1909 water treaty between United States and Canada. This is one of the oldest treaties on shared river water. And that treaty, after that, they entered into a number of supplemental agreements, treaties on Niagara Falls and Great Lakes. And in all those treaties, they have incorporated environmental aspects. Earlier, it was not there. In bilateral treaty 1909, if you read it at that point of time, because perhaps one of the Regency scholars are saying that United States was in the grip of Harmon doctrine. It was not in a position to cede, because it was thinking we have not to cede anything. Okay. So the International Joint Commission, the body that was in research as per the 1990, its scope has been expanded. Earlier it was boundary, like permanent court of this Indus Water Commission. It will be seeing the border. It will be exchanging the information. The idea is that it has to be empowered in the given situation, isn't it? Because it is not possible in a situation of power asymmetry that we see between India and Pakistan, and Prime Minister Modi has said the blood and water cannot flow together. It represents serious lack of trust between India and Pakistan. So in that context, it is very important that we must explore the possibility of World Bank. World Bank, another party to the Indus Water Treaty, and it is in a position to forge boundary alliances among experts, water engineers, hydrologists, okay, and that alliance will help in finding that they will help in revisiting the Indus Water Treaty. We have example of that in Mediterranean in 1970, where the epistemic communities, they got together, all the marine biologists and all the engineers, hydrologists, they came together on one platform and they started, and they have been able to find a solution to the Mediterranean Sea. Okay, so in the same way, we need to think that in a situation of climate change, when there is going to be fluctuation in the flow of water, if you see in the Kishan-Ganga water arbitration, India has been asked that we have to maintain minimum flow, that is 9 cubic meters per second. Okay? This India has to maintain. India has been allowed to go ahead with building of hydropower on Kishan-Ganga. It has been allowed to intertributary, that the transfer of water can do to build hydroelectricity, isn't it? But at the same time, it has to maintain the minimum flow. And suppose it is not able to maintain the minimum flow, so and not only that, if there is water availability is less, then it will definitely affect energy production also. Energy production, and of course several other things are going to be affected, that the irrigation facilities are going to be affected. So we have to find a situation, we have to sit together and think that this is the availability of water, and on the availability of water we have to decide what is the best use of it. What is the best use of it? In a situation of crisis, what we will be doing? The top priority has to be given to the vital human needs, isn't it? Vital human needs. Okay. So there are, of course, the criteria has been laid down in the United Nations Convention on Non-Navigational Uses of Water, 1997, and then there is provision in Article 5, equitable and reasonable utilization. All the criteria have been laid down in that is Helsinki rule. So Helsinki rule is not the ultimate thing. Helsinki rule is not that we can have another system. Okay? Apart from these criteria, if we find that there is something which is other than, then we have to equitable and reasonable. We have to find how we can have access, how we can have beneficial uses of the water. The argument is beneficial uses of the water. In a situation of adverse effects of climate change, it will be contingent on the availability of the water. How much water you have available, and then you have to decide the allocation strategy. We have to find if you read how Israel and Jordan, they have been able to find a way out of to meet the situation, to meet the climate change situation. In 1964 water treaty agreement between United States and Canada, they have entered into another agreement relating to Columbia River water. If you see all the river waters, how they have been, the countries that the riparian states are trying to remake the water treaty to suit the environmental situation, not the partitioning of the river. Partitioning logic is completely flawed. It might have served the purpose at that point of time, but it has partitioning logic has, because when the countries were not thinking in terms of building hydropower, now they are thinking in terms of building hydropower. So it is better to sit together and revisit the treaty in the context of climate change, in the context of new standards. That is the new technical standards, new norms, as current norms that the Glasgow Agreement was the International Court of Justice has said, that we must evaluate the treaty in the context of new standards, not the old, that when the treaty was entered into at that point of time, climate change was not looming large. Now it is looming large, so we have to adjust. We have to adjust to a new norm. Okay? So we have to adjust to new norm. So these are some of the points which I find that is very useful if we see in the context of climate in this point. Thank you very much for listening.
Thank you, Dr. Anand. I now call upon the next speaker, is Dr. Ram Prasad. Dr. Jaishankar Oza, Mr. Naveen. Mr. Naveen would speak on integrating climate change with consideration across sectors, building a coherent response for sustainability. You have the floor.
Good afternoon, one and all. So, my name is Naveen, and I'll be speaking on integrating climate change across sectors, building a coherent response for sustainable development. So, since I'm discussing on the sectoral approach, I just want to highlight how different sectors are contributing to the climate change. This is how the world, at the global level, how different sectors are contributing to greenhouse gas emissions. This is a 2016 picture. And this figure shows that energy is contributing to the maximum greenhouse gas emissions at the global level, constituting 73.2%. And then next to this energy, you can see agriculture is contributing. Agriculture, forestry, and land use change is contributing 18.4%. And then waste is contributing to 3.2%, and industry is contributing to 5.2%. So they are all functioning under different spheres because energy is being used for all developmental activities. From that perspective, it is contributing towards greenhouse gas emissions. Now, we all know that greenhouse gas emissions from fossil fuels are inherently linked to economic growth and are still used to drive prosperity in the world. But we also know that the uncontrolled human activities have been resulting in greater concentration of greenhouse gases in the atmosphere and intense warming of the climate system. And when you take the case of impact of the climate change on the countries, you can see that the developing countries like India, who are highly exposed and vulnerable to the problems of climate change, are strongly impacted by the causes of climate change. And in fact, the IPCC has highlighted or pointed out to the other basic inherent problems which developing countries like India are facing, apart from the problems that climate change is going to impact. So some of them are inequality, poverty, population growth, high population density, land use change. And in fact, developing countries like India have been largely depending upon the natural resources for its production of commodities, both at the local as well as the national level. So this shows that the problem that is being faced by developing countries comes from two sides. One is from the impact of climate change. Apart from that, while trying to address the problems of climate change, we are to face certain other inherent equity issues that we already have. So IPCC again in 2002 has said that to avoid disastrous consequences, global emission needs to be halved by 2030, which shows that we don't have much time to act and the action should be urgent. Now this is how the atmospheric concentration of greenhouse gases there. You can see that in 2023 it is around 420 parts per million, and the most significant transition or changes have happened during the last 3 decades after the globalization in 1990. So there's been a significant change. This is around 800,000 years of transition over the period of time. Now we are in a very huge status of carbon dioxide emissions, and we all know that there is a lag between the atmospheric carbon dioxide concentration and the temperature, because whatever consequences we have been facing right now are because of the emissions that have happened so long before. Because these greenhouse gases remain in the atmosphere for a long period of time, and the impact that we are facing are those which has been emitted long before, which means that this 420 ppm of carbon dioxide emission, which is at now present in the atmosphere, will be creating more havoc in the long duration. But in fact, we have to have a realization that all these factors cannot override the fact that climate change impacts productive development. So we know that from a developing country's perspective, development will help us in addressing the problems of climate change. At the same time, climate change impacts are also creating problems for us. So we need to address in a very sustainable manner when it comes to compacting or addressing the problems of climate change. So in fact, the multidimensional character of climate change demands attention and cooperation of different sectorial stakeholders. That is why I will be concentrating more on the sectoral approach in addressing the problems of climate change. So which means that India needs to mainstream climate change consideration across different sectors to ensure a sustainable and progressive development. Now, this is what we understood from the figures that we have seen so far. Now, coming to the most important agreement, the Paris Agreement, which will be leading us ahead in the coming years to address the problems of climate change. We know that the Kyoto firewall has been broken. There is no significant divide between the developed and the developing countries. We don't have any annex or annex 2 or non-annex countries. So from now on, we all have a common platform to address the problems, where we can ourselves self-determine what we should do to address the problems of climate change. That often is criticized for various reasons, whether we should be ratcheting up the ambitions over a period of time. So that's a totally different issue. But when we try to address the problems of climate change on the basis of Paris Agreement, the Paris Agreement clearly states that we all nations, all the parties or states have to take up long-term temperature goals, and the temperature goal set is around less than 2 degrees Celsius, and pursue to restrict the temperature level to 1.5 degrees Celsius. So which means that there are two options available for us, which is actually rapidly reduce resilience on fossil fuels. Another one is scale up the use of alternative resources. So in fact, while taking up measures in these two aspects, we'll be addressing majority of the problems that we have been facing in different sectors. Now to see whether we are doing these activities, as Professor Asadat sir has rightly pointed out about the importance of national determined contribution, it is actually all the states have to prepare, communicate and maintain successive NDCs, national determined contributions, every 5 years. And in fact, they are supposed to advance their ambitions every time, but the Paris Agreement is not clear about what should be your basic ambition and how much you should enhance over the period of time. These are all issues that we are facing with regard to addressing the problems of climate change. And in fact, the Paris Agreement has requested or asked the states to pursue domestic mitigation measures with the aims of achieving NDC, which means that if NDC is being submitted by a particular state, especially including India, then India has to pursue actions at the domestic level to address these problems. And we are very well aware of the recent developments that happened in the 2021 Glasgow, where India has agreed to a net zero carbon emission by 2070. And again, this net zero emission is a legally conflicting issue because there's no clarity about what constitutes this net zero carbon emissions. There are a lot of issues how to reduce the emissions, or using sinks, or etc. Now again, to COP26, the government of India has introduced or submitted a 5-fold strategy called Panchamruta, and here India has submitted that India will get its non-fossil fuel energy capacity to 500 gigawatts. India will meet 50% of its energy requirements from renewable energy by 2030, and India will reduce the total projected carbon emission by 1 billion tons from now onwards till 2030. 2030 is the closing window time which IPCC has prescribed. By 2030, India will reduce the carbon intensity of its economy by less than 45%. And so by all these measures, India is actually aiming to reach the net zero emissions by 2070. So a lot number of countries have submitted their net zero emissions. China has also submitted their net zero emissions. They have said that they'll come to net zero emissions by 2060. And very few countries like Madagascar has already achieved their NDCs, but many countries have incorporated these NDCs and net zero emission targets in their policies, or very less countries have incorporated into their legal documents. So in fact, all these commitments made by India over a period of time, and especially during the recent negotiations and COPs, we can see that we have to realize that the future decarbonization policies and actions are important and have to be very realistic in terms of addressing the problems and fulfilling the commitments. Now I just wanted to show you what was the kind of emissions and that has happened in different sectors over the period of time. So here you can see that in the year 1990, agriculture was emitting to 566 million tons, and electricity and heat was in second with 232, and manufacturing and construction 151. So you can see all these are the figures which was there in 1990 with regard to greenhouse gas emissions sector-wise in India. And now, moving on to the sector-wise emission in 2008, I wanted to take up 2008 because that was the year when India actually initiated the National Action Plan on Climate Change. You can see that agriculture has come down to second, and electricity and heat has enhanced or increased to 725. Manufacturing and construction, transport, building. These are all important sectors where there's a large concentration or emission of greenhouse gases. Now in 2019, where do we stand? Here you can see that electricity and heat has gone to 1.24 billion tons, agriculture 719, there's a gradual increase only, but a significant increase can be seen in electricity and heat, manufacturing and construction, etc. I just want to see the final output of this. So this is the sector-wise developments with regard to the greenhouse gas emissions. In 1990, agriculture was 566, 2008 687, and 2019 719. It's a gradual increase, but electricity and heat, you can see that 232, from 232 in 1990, you can see that it has gone to 725, almost 3 times the increase in 2008, and again in 2019, double the emission it has gone. Now it is 1.24 billion tons in 2019. That's a very huge increase. Now taking into consideration the population of India and the future demands that is going to arise, you can see that this 1.24 will only increase, maybe it may even double. So again, all the other remaining factors have been highlighted. I can see that construction is again doubled in 2008, and then again increased by another 200 units in 2019. So there is always a gradual increase over the sectors. So what the main point is that in 2018, we came out with the National Action Plan on Climate Change. Based upon that, we have initiated a lot number of measures to address the problems of climate change in different sectors and under different ministries, in fact. But the gradual decline in emissions cannot be seen or is not reflected in any of the data that are available. So this is basically the graph which shows that how we have been progressing from 1990 to 2019. There's a severe increase in electricity and heat, and it is going to increase more with demands of energy or with the increase in population and population density. Now you can see that the Paris Agreement goal and the Sustainable Development Goal has reconfirmed that growth and development cannot continue without all countries tackling climate change and boosting environmental sustainability. Here again, the emphasis is that Paris Agreement does not see any kind of differentiation between the countries at the global level, and even based upon the statement made by the Chinese and the United States, now CBDRRC principle has been increased to include upon national capacities. So here it is all self-determined and parties are free to make their choices. But again, everything is subject to a top-down approach where there is a global stock take where the countries will be subject or exposed to the their developments or their contributions, commitments, and their output based upon the commitment. So the real question is, can we make progress in reducing emissions? So there's a strong link between carbon dioxide emissions, prosperity, and standard of living. So if India should make progress in reducing emissions, we would have to achieve both high standard of living, low level of emissions, or at least large reductions in emissions to maintain the standard of living. So this would be some kind of a sustainable development approach. So some countries have been successful in reducing the emissions, clear signal that it is possible to make progress. But as far as developing countries like India, it is again important to highlight that it can be possible only with support and solidarity of the developed nations. Now this is how, with regard to this emission reduction and the GDP, the development perspective, you can see that both are going high. The GDP is also high, as well as the production and consumption emissions are also high. They are parallelly going at the same rate from 1990 to 2021. Now you can see the difference, what has happened in UK. I'm not trying to equate the resources that are available in UK, whether it is with regard to finance or with regard to natural resources, but I'm just trying to point out that it is possible, they have been doing it, and as far as developing countries are concerned, it can be possible only with the support from the developed countries as well as the multilateral bank. So here you can see that the GDP has enhanced, and the consumption emissions as well as the production emissions has gone down. So here, this is the best way of getting your high standard of living, as well as committing, as well as fulfilling your commitments of reducing the greenhouse gas emissions. Now this is what the policy scenario is. Here you can see that if you don't have any non-climate policies at hand as of now, the increase in temperature would be 4.1 to 4.8 degrees Celsius. With the current policies in hand, our reduction or temperature would be around 2.5 to 2.9. And if the pledges that we have taken, it is a global scenario. Pledges, if we are able to fulfill, that will be around 2.1 degrees Celsius. And if we take better pathways, it is 2 degrees Celsius and 1.5 degree pathways. These are the best pathways that we have to adopt. But even the real fact is that even if we stop reducing the emissions now, we will have to face the problems of climate change. So that makes adaptation policies also more important. Now, but the key question would be like how fast or how, because where we can make the progress at a very fast pace, that is to achieve 1.5 degrees Celsius. The current pace is too low, too slow. The world is currently far off the track from our 2 degree Celsius target. There is a need for large-scale acceleration of these efforts across the world. So despite sustained efforts, India has missed its 2022 target of 175 gigawatts renewable energy capacity. This was a commitment made by India in the last 5 years that we would be reaching 175 gigawatts of renewable energy capacity by 2022, but we couldn't satisfy that commitment. So transitioning from the current development pathways to low carbon climate reliant is inevitable. That is true. Transition is inevitable. Transition of any kind in the society will bring opportunities and challenges, no doubt about it. But again, when it comes to addressing the problems of climate change from the perspective of equity, developing countries will have a lot of problems to address. But still it is inevitable, so it requires significant investments and innovation. A shift in the way government and its different sectors makes the decision is also relevant in that regard. Now what are the commitments India has made? India's meeting the target of 2030 that requires accelerating non-fuel capacity addition from 16 gigawatts a year in 2022 to 75 gigawatts a year in 2023 at 22%. 22% year-on-year growth is required. So I'll be just concluding. These are some important policies that have been adopted in India during the after the NAPCC has come into effect. Super efficient equipment and appliance technology, SEED, which talks about manufacture, purchase, and use of energy efficient appliances. Green Energy Corridor Project, which talks about synchronizing energy produced from renewable resources, and mission innovation, encouraging new innovative technologies for an effective long-term global response towards climate change. And International Solar Alliance encourage potential solar-rich countries to make use of the available solar resources. Green Climate Fund, groundwater recharge, and solar micro-irrigation to ensure food security. This is actually happening in the tribal villages of Orissa. But all these measures have not been sufficient enough to address our commitments that we have already taken up. Now, the Central Electricity Authority has projected a near doubling of electricity demand by 2030, basically because of the population explosion. Now, energy demand in India is likely to multiply requires adequate supply from diverse mix of sources. And as far as India is concerned, to address the problems of climate change and address the problems of the inequality and other basic problems being faced by India, development cannot be frozen for decarbonization. So the best way is to scale up such approaches and through additional supplementary measures. And so the different sectors can actually mobilize resources, knowledge and innovation for addressing climate change and promote green growth, and it can optimize resource use and improve environmental performance. And there's a need for innovative solutions in the area of climate change mitigation and adaptation. It's an opportunity for the different sectors to develop new products and services and serve new markets, because carbon is coming up as a new product in the trade sector, and like any other product, carbon will flourish in the future time. So India should look into the carbon market also. So two important sectors that I should look into is energy and agriculture and food. Sir, can I take one more minute? Yeah. So key action is improving efficiency, transition to low carbon alternatives. Now, emission reduction in food production and agriculture is also important. We can convert to products like chicken, fish, and eggs. Innovating in meat substitutes another option. Reducing food waste, because 1/3 food emissions come from wastage in supply chains and consumers. So that is also very important. Improving harvesting techniques are another important measures that can be addressed. So decarbonization transition to renewable energy is going to be the biggest transformation since the Industrial Revolution. To ensure social justice, resilience, and sustainability, an inclusive and comprehensive just transition policy should be integrated to any climate action at the sectoral level. Thank you.
Thank you. We will take questions later. Make your presentation. We have Professors Pratap and Swati. They will be speaking on Sustainable Action Plan in India, Law and Policy.
Respected Chair, respected dignitaries on the dais, off the dais, colleagues, Dr. Swati and Krishna, presenting here the Sustainable Climate Action in India, Law and Policy Leaders. Before going to the topic, we need to know why life is the sacrosanct and needed to be protected on the earth. Professor B.P. Nanda has suggested that life on the earth is just because the earth is tilted on 23.5 degrees, and by that the earth is moving around the sun, and there is the life on the earth. And constantly there is a change in the temperature in every kind of like summer, winter, and the other things that is happening. Right now, if there is the constant the changes, that is, we have the weather. But if it is instantly changing, the temperature can instantly change, that can be in terms of climate. So whether the climate change is happening, and if it is creating problem to the person, then certainly it is one kind of the question and one kind of the problem to the human being as well as other living beings. What are the reasons that the changes are taking place? We have, after the Rio Declaration, we have conquered not only the Rio Declaration but the Stockholm Declaration, and we have passed this 50 years after the Stockholm Declaration. And Stockholm Declaration, Rio Declaration, Brundtland Commission report, they have all coined the term sustainable development to different kind of things, and whether we are achieving the sustainable development or not, that is the one question. So here I'm just going through few aspects of the sustainable development, that we have the environment, the development, and the stability. Three pillar of the sustainable development. And if we talk about the principle 3 and 4 of the Rio Declaration, that is important here because when we are going through the development process, whether it is creating any problem to the next generation or not, and certainly the Rundgren Commission has also suggested the development that meets the need of present generation without compromising the ability of future generation, that is the sustainable development. And for doing the sustainable development, whether giving definition that will be sufficient, so certainly not. So we have come across the different kind of COP, and the IPCC has suggested that if there is no such type of control on the part of this temperature, certainly the glacier will be melted by 2035. So we have come across the Millennium Development Goal and the SDG. Right now, we have to see whether the SDG, what we have adopted, are actually fulfilling, whether we have gone through the policy or the law relating to SDG. That is the question here. That is the moot question, because we have, after the Bhopal gas disaster, the Environmental Protection Act and other legislation like the NETA and NIA right now repeat, and National Green Tribunal Act is working there. But actually we have worked upon after the Paris the climate conference or not. That is the question. So certainly after this the Paris climate conference, and when we have adopted the sustainable development goal, and that would be achieved by 2030, that is the question here. So I'm not going to much of the discussion on that part, just leaving to other part. What are the responsibility of a state in terms of when we are adopting the international law into our municipal law, like Article 51 that suggests us to honor the international law into our municipal law. And if we talk here, the other kind of things, like preamble talks about justice and equity, and in terms of the environmental justice and the equity among the generations to come, we certainly need to have the law that is regulating the pollution which is not traditional one, which is not the pollution that is the conventional one. So if there is unconventional pollution like hazardous waste, like municipal waste, like after the COVID situation, we have the problem of the face mask, whether there is any provision to dispose of that, whether the single-use plastic that is used and that is creating the river pollution and other marine pollution, that is whether that is that is that is regulated or not, that is the problem. So whether only the judicial system they will cure the problem of the environment, that is the question. Second issue what we have like in the case of this research foundation, where the Supreme Court has gone through what is the responsibility of the state. Apart from that, there are various cases, but not like Sachidanand Pandey and other cases too. But this is a recent case where we have seen the concern that is made by the Supreme Court, Honorable Supreme Court also. Now, few other what are the problem we are facing? Most of the industry that is based on that is releasing nitrogen and sulfur-based pollution. So whether that is creating climate change, and carbon related gases is also responsible for that. There are certain issues by way of the climate change. What can be thereafter if there is climate change? Certainly there will be increase in the temperature, and that will rise in terms of there will be kind of the melting of glaciers. There are certain diseases that is happening due to the rise of the temperature, and it is expected and it is suggested that also that there may be chances that in 2080 there may be dengue problem, because in rise of temperature it will create the kind of the submerge of many kind of the places, many kind of country also. Again, the problem of the refugee that is related to the climate refugee. There is question again. We have the provision for the refugee, but whether we have addressed much for the climate refugee, that is the one issue. So human right issue due to the climate disaster and climate migration, that is one issue that must be addressed. Again, other problem we have like resettlement and rehabilitation. So there is one problem, sir, in the context of, if we talk about the Narmada Bachao Andolan case and Tehri Dam, suppose there is any project like mega project is going on, only we are addressing the people who is living in the metro cities. Like we are here in just in this AC hall, and we are getting this electricity. So certainly this electricity is being generated from elsewhere. It is transmitted here. So question arises here: who has been rehabilitated or resettled? They have lost their cultural life too. So cultural losses is also there by way of this resettlement and rehabilitation process. So in the cost of other cultural rehabilitation, in the cost of others' right to life and the other kind of human right, we are enjoying. So whose right is superior right? This is the question again. So the Narmada Bachao Andolan case and Tehri Dam case, where the project was allowed. The case of this Sundarajan versus Union of India, it is the case related to the nuclear project where electricity is generated, and there is doctrine of proportionality is added. And doctrine of proportionality is talking about if there is any kind of development and the development is benefiting to more of the person, certainly there can be loss to minimum person, and it can be ignored. So again, question arises on the cost of few persons. If there is the development is done, whether certain right can be safe, there can be safeguard to the right of the person. Again, few question arises. The climate refugee is there, climate change, that is directly connected to one issue. If we do not address this climate change and climate refugee, there can be the challenge regarding climate crisis too. In coming days, if there is climate crisis, certainly there can be the sovereign country who is giant country, like right now Russia, Ukraine war is going on, and due to this the natural resources itself. So if there is climate crisis in coming days, the natural resources that will be used by the sovereign country who is more giant, who is more powerful. So that is the one question again. So this climate refugee right now, it must be addressed in terms of where two countries are there, where even within the state, if that is creating the problem, and it must not go up to the political crisis. Again, in terms of the principle 2 of the Rio Declaration, principle 21 of the Stockholm Declaration, and principle 3 of Convention on Biological Diversity, we will talk here. The good neighborliness principle and no harm principle is mentioned there in terms of one Roman magazine, Sic Utero Tuo, et alienum non ligas, means the sovereign state must not harm or must not infringe the right of others. So certainly they will adhere the international law principle, they must adhere what the treaty they signed. But if there is natural resources that will be limited, whether that the principle 2, principle 21 and principle 3 will be safeguarded or not, that is the question again. So in the light of the climate change and if there will be less natural resources, certainly this international law principle will also not be uh, 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 adopted, and that I think the most of the sovereign country, which is giant company, they will again ignore the they can ignore the things. Here only we are saying that always transboundary pollution is harmful. I will here mention few things. Always transboundary environmental pollution is not harmful, but domestic pollution is also carrying serious environmental problems, and therefore we must revisit our the Indian law and policy what we have right now. If we talk about like the ICJ Article 38, where certain binding force is mentioned, just I have to okay. So I have to conclude in 2 minutes. So let me talk about few suggestions we have. BP Nanda has suggested it can be rise in 3 to 9 degrees Fahrenheit, and therefore we must go through certain peremptory norms and erga omnes. And I will talk here few suggestions because we have less time. We have the concept of everything like sustainable development, generational equity, to all other principles. But here, what if we talk about climate actions to saving the energy, one thing like consumerism is also the reason for the climate change, because every product that needs to the generation of the carbon. If there is any kind of product, there is emission of carbon or nitrogen or sulfur. If I am correct, so there is more use of the things, there will be more generation of the carbon. No doubt there is the economic development is also circulation of money that will be beneficial for the economy of the country, and but same time there are other things by which we can go for climate action, like save energy at homes. One can for transport, they can pull the car or for use the bicycle. Again more vegetable that is required to be eaten, and other things like renewable energy that can be used. Apart from that, these are few suggestions that can change domestically, but the certain problem like extreme weather, livelihood crisis, climate action failure, social cohesion, certain infectious disease, certain even mental health condition that can create problem. These can be the reason for the region of the climate change. So what is required to be addressed? We must go through to address the climate sustainability in terms of the SDG 1, 2, 4, and 3. That is connected. Poverty, zero hunger, quality education, and good health, well-being. These are the issues that must be addressed. One Center for Science and Environment, I will just tell about. They have made research, and they are doing research every year on the environment on certain parameters. and they have suggested why the certain state are below in the SDG index, and there are certain parameters like if we talk about the like hunger, so whether one has the sufficient means to take the meals properly in so what is the quality of the person, what is the earning capacity, whether he is BPL or not. So these are whether they have household or not, whether they have toilet per person or within the household. These are certain issues on the grassroots. It must be addressed. So that is the some suggestion regarding if we talk the SDG, it must the data must be collected and through the grassroots from the rural areas only. After that, the policy may be again my last suggestion is regarding carbon tax law and policy. So we have the environmental law that is addressing two things, like what kind of we have like public trust doctrine, which is giving right to have the public trust like water, air, free of cost. But if the water, air, all the things are used for commercial purposes, it must be taxed for the environment. This is my last suggestion. Thank you. The time is also not permitting me to. Thank you, Chair. Thank you, organizer. Thank you all.
Thank you. I'll not speak, I can see the watch before me. We need to give some time to people who have been patiently listening to the speakers. And any questions? Those of you, yeah. Yeah, go ahead. Can you stand up and introduce yourself, please? Sorry. We'll take questions and then. Yes, sir. Sure.
Thank you. And thank all the panelists for all the presentations and suggestions they have given us. Now Dr. Anwar Sadat has spoken in depth on the Indus Waters Treaty, and he had many suggestions to make in view of the changing circumstances, climate change, changing in rainfall patterns, etc., and the availability of water. Now, all these suggestions are very good, but we have to ask ourselves, given the negotiating history of the Indus Waters Treaty, how realistic are they? The Indus Waters Treaty was negotiated with the intervention of the World Bank. And probably this is the only bilateral treaty which is also signed by the World Third Party. And the formula which was adopted of dividing the eastern and western rivers, that also came from the World Bank. after all suggestions of dividing the waters or sharing the waters of the rivers, of allocating shares to each side, those did not succeed. So in this kind of a situation, can we really hope that if we try to reopen the treaty, we will again be able to get agreement? As far as the current treaty is concerned, it has worked well. We have had disputes, but they have been settled under the terms of the treaty. And we have a long history of cooperation, of implementing the treaty. And you may be surprised to know that at one stage, even when we were in an armed conflict in 1965, during the conflict itself, the Indus Waters Commission was meeting. So this gives us hope also for the future, that we can continue to cooperate. But I don't think we can agree on further division or a further change in the pattern by which the waters have been shared between India and Pakistan. The Kishan Ganga project, which Dr. Anwar mentioned, about the water being released below the dam. This is a particular situation because the waters from the dam, which will be used to generate electricity, they will not be going back into the channel. They will be going into the river through a different route, which is why this question of leaving some water for environmental purposes, that issue had arisen. Now when there is cooperation, India and Bangladesh have been able to agree on the Farakka project, where there is a weekly quota which is assigned to each. A certain week, a minimum flow is assured during the lean season. For 1 week to one party, the following week the other party gets that assured flow. So there is a zigzag pattern in that flow. But this is because you could agree. And even that pattern is based on the average availability of water based on previous calculations. But there's no guarantee that every year that water would be available. And so the treaty provides that if the water is less than what has been envisaged, then the parties would consult. Now in the US, you mentioned the US and Canada. But I think the biggest issues in the United States have arisen in water agreements between states. When you study international water law, most of it is made up between the litigation between Kansas, Colorado, or Colorado, Wyoming, and different states. Currently, they all have long-term agreements. Those agreements were negotiated for 100 years. But very soon, those agreements are going to come up for renegotiation. And we'll have to see how those renegotiation goes and how the voters, how soon or how easily they can agree on. So I think we must wait for that.
Any more questions from the students? Are you also together? Thank you then.
It was an excellent intervention by Narendra sir relating to my presentation on Indus Water Treaty. That the treaty was conceived in the context of partition of India, Pakistan, and scholars, recent, many scholars which I went, that the Bill Martin has written a book on blood and water cannot flow together. So, oh, sorry. So, both the countries were at the time of negotiations, they are possessive of that there is one paper on, I can say, that I was reading it, and that they wanted, that the sovereign concern was, so competing sovereign interest was so high at the time, they wanted to have the river. In fact, that both the positions were really indicated that the Harmon doctrine was prevalent. That one of the yardstick was Harmon doctrine, because equitable and reasonable utilization was not there. So the idea was that both the leaders, both the country's leaders, were that the rational idea would be to partition the water, partition the river, not the water had. And eastern side sector went to India's side, western sector went to Pakistan's side. So, and it doesn't address groundwater. If you read it carefully, groundwater is not addressed. It is surface water only addressed in the Indus water. Groundwater is not addressed. Climate change is looming large. Sir has correctly mentioned about the water and this. Somewhere countries are renegotiating their water treaties in the context of drought, in the context of desertification, in the context of their storage capacity. Isn't it? They are renegotiating their water treaty. They are trying to insert some escape clause. They are trying to insert in the treaty a climate uncertainty mechanism. That this is the uncertainty coming up. If this uncertainty is there, so we will release in this period to you this much of water, and I am entitled to get this much in winter. Like if you read, I studied it. So seasonal, in light of seasonal variation, we will get the allocation of water. So as regards World Bank, yes, sir. As regards World Bank, as sir has beautifully summed up the negotiations, World Bank is a party in this, and World Bank has a role in arranging. The neutral expert has a role in arranging arbitration, has a role in reconciling the differences between India and Pakistan. And World Bank has such a overwhelming influence in many sectors, of course, that it can forge alliance of experts. It can forge alliance of those experts who have common knowledge, who have shared understanding of that water use. So they can come together. If you read the 1970s Mediterranean Sea history, and that the experts of all the Mediterranean Sea, they came together under the aegis of United Nations Environment Program. And it has been able to forge that alliance, and then treaty became that Mediterranean pollution was reduced. The World Bank is one of the better options to guide both India and Pakistan in the context of climate change. I see that it can be one of the solutions.
Another session coming up. As a chair, I'll use my prerogative to just sum up the discussion. And I'll say a sentence or two on all of these presentations. Regarding water resource and water resource utilization, I think that the topic which Dr. Anwar spoke was climate change, is water use, Indus Water Treaty, and climate change. Climate change is not yet evolved as a concern in sharing of fresh water resources. In fact, the Western countries would be very happy that the water resources in the entire developing world start looking at climate change concerns in fresh water resources, just like they have done with regard to to, ocean acidification. They want, the oceans and climate change to be linked up, just like they want, animal husbandry and agriculture to be linked with climate change. I think these are, one should be wary of this. Share reasonable utilization of water resources and significant harm is in one place, and climate change is in another place. Simply because although rivers do contribute to some form of pollution, there are any number of treaties that deal with water. Climate change in itself is not as big a concern of utilization of water resources. I think it is to stretch the argument one. Then the other two papers, some of you people didn't come. They speak on the general, climate change regime and what needs to be done and what India has done. Naveen spoke and Dr. Swati and Mani Prakash spoke on this. But while doing this, you must also, I think, be aware as to what the negotiations are, what is the Western world's view, and more than anything, we must know the negotiating history of these treaties. These three treaties, the UNFCCC, the Kyoto Protocol and the Paris Agreement, they have been, adopted not only in a particular context, but they have been adopted with a fundamental understanding that the major polluters of the world, maximum contributors to greenhouse gas emissions, are the developed world, and it is for them to take the lead in any form of reduction. Now the most latest regulations that are negotiations that are going on from COP25 in Glasgow and then COP26 in Sharm el Sheikh, the issues are the same, but now what we have, what is the Paris Rule Book, and the challenge is operationalizing this Paris Rule Book regarding issues such as mitigation, adaptation, climate finance. We have a loss and damage fund now. So many of these issues are, I think, as scholars and as people who are researching, you need to look at these fields. These are very challenging fields. Mitigation is something which the developed world wants. It says that you please reduce your carbon emissions, which would directly affect your economy. And the developing world largely wants adaptation and loss and damage facilities. In fact, the developed country have not even provided 2019 figures of that $100 billion climate fund. So I think this needs to be first met. Climate finance is the key to the poorer countries of the world actually coming together in any form, meeting their greenhouse gas emissions, and the lead must be shown by the developed countries. I thank you all for this session, and I think we'll wait for the next session.
Thank you, sir, and thank you all the panelists. So we have 10 minutes break, tea break, and we'll join here for the last session on human rights.
Hello.
Chiranjeevi Panda, Miss Sophia Khatun, good evening all. Now we have our plenary session 2 on the theme human rights law, and we have with us Chair Professor Rashmi Salpekar ma'am, Dean and Head Whips Professor Manoj Kumar Sinha sir, Director ILI New Delhi, and we have with us Dr. Kishore Singh, former UN Special Rapporteur on the Right to Education, to present keynote address. We welcome you sir and all the panelists. Ma'am, over to you. You may start. Manoj sir, you can give the introductory remarks first. So, good evening all the panel and my dear audience. So we are here for the session on human rights law. Since yesterday we have started this conference, and since morning we have a very good technical session. Even though the technical session on human rights is at the end, but however we treat human rights on priority, on the top position. So with this, I'm having, I would say that very good speakers on the panel. So thus we can see that how far we are really taking seriously human rights. So all the panelists, I'm very happy that they are having different topics to speak. I'm extremely fortunate that in this session, introductory remarks will be delivered by Professor Manoj Kumar Sinha, Director Indian Law Institute, and plus Vice President of Indian Society of International Law. And keynote address will be delivered by Dr. Kishore Singh, former United Nations Special Rapporteur on the Right to Education. So both of these speakers, they do not need any introduction because all of us, we have referred the literature developed by them and also the work which they have contributed. So we have referred it extensively. So with this, without taking much time, I would like to invite first Professor Manoj Kumar Sinha to give introductory remarks.
Thank you, Rasmi. Thank you very much. All the dignitaries on the dais and off the dais. But Rasmi, it's a role reversal. So I prepared for the keynote address for 1 or 2 days, and even for today I was busy, but I did. So I think I will continue. I need more time. Whatever introductory remarks, but I'll continue for 7-8 minutes and try to explain. And then what I thought, is a session for the international human rights law. And when we talk about the human rights law, we more focus, and particularly in the international law perspective, we focus more on the international normative framework, and that I mean the treaty-based human rights instrument we discussed. I personally believe, and many of you may agree with that, how the Indian judiciary also started recognizing, it was always there, and some of the cases they have deliberated in detail about the human rights or obligation under the international law. And how that has been done, I'll just bring 2-3 cases and then we'll discuss. As you all are aware that in the domestic perspective, after S.P. Gupta case and also by the People's Union for Democratic Rights of the versus Union of India, which was decided, there are many cases, but AIR 1982 and SC 147, where court has widened, diluted the concept of locus standi. They said the locus standi and then given public spirited individual to approach the court. And since then we see transformation we have strong jurisprudence developed through the Supreme Court of India and High Court of India after dilution of the concept of locus standi. The another point, there are a couple of points are there. So let me start with the first point, which I generally discuss in the class also, the starting point for the human rights discourse with the section 2D of the Human Rights Protection of Human Rights Act. Protection of Human Rights Act is the only act where human rights has been defined. What human rights means, definition part is given. Section 2D says human rights means rights relating to life, liberty, equality and dignity of the individual guaranteed by the Constitution or embodied in the international covenants enforceable by the courts in India. So it has twofold definition. It takes note of the international human rights instrument, constitutional perspective, and it also looks into the international human rights instrument and particularly international covenant and civil and political rights and international covenant and economic, social, cultural rights. Let me start with the first case where Supreme Court has talked about the international. Quickly, I'll just try to complete the Visakha judgment. Visakha judgment. So, like when a student of international law should not read international law in isolation. I believe we have Ansul is a student here. They should look into the international law more in the domestic perspective and how the courts have highlighted. And court in this particular, which many of you uses in paragraph 14, it says any international convention. So how court applies international law in the domestic level? So court in paragraph 14 says any international convention not inconsistent with the fundamental rights and in harmony with its spirit must be read into these provisions to enlarge the meaning and control thereof to promote the object of constitutional guarantee. So not if law is not inconsistent, then there is no problem court to apply. And this is implicit from Article 51C and enabling power of the Parliament enact laws for the implementing. It also says, thus the power of this court under Article 32 for enforcement of the fundamental rights and the executive power of the union have to meet the challenge to protect the working women from sexual. So I see that this case can also very important case which we all refer in our discussion. The another important case where we find that is the Chairman Railway Board and versus Chairman Railway Board and others versus Chandrima Das. And their court observed something I have already said, and so this state has argued in this case that they contended that Hanifa Khatun, she was a Bangladeshi woman, she was sexually assaulted in the railway board, railway Jatri Niwas in West Bengal in Calcutta. So courts the government lawyer saying Hanifa Khatun was a foreign national and therefore no relief under public law could be guaranteed to her as there was no violation of fundamental rights available under the constitution for the foreign national. That is the contention we made. But now what court interesting part, that is the reason I read out this. Court said it was contended that the fundamental rights in, then it says, it was contended that fundamental rights in part 3 of the constitution are available only to citizens of this country, and since Hanupa Khatun was a Bangladesh national and cannot complain of the violation of fundamental rights, and on the basis of that she cannot be granted any relief. Now come to the court point. Court says this argument must also fail into two regions. First, domestic jurisprudence, so we'll look into the domestic jurisprudence, and second, on the ground of human rights jurisprudence based on the Universal Declaration of Human Rights, which has the international recognition as the moral code of conduct having been, and then court goes on that particular. So court has, in fact, in this case, the court has completely covered all the article of the Universal Declaration of Human Rights, but preamble starting with comparison that has been done. So you see the judiciary, how much pain it takes. And then one part, last point is I have from this case, the international covenants and declarations as adopted by the United Nations have to be respected by all signatory states, and the meaning given to the above words in this declaration and covenants have to be such as would help in effective implementation of these rights. So the quote goes on this. So just two cases I said where effective implementation of international law has been realized and also been referred by the Supreme Court of India, and since then there are many cases with it. Now the another two important point which maybe Narendra Singh will be happy to know that is, sir, there are two cases which are pending before the Supreme Court of India. That is the one, sir, is the Suleiman versus Union Ministry of Home Affairs, and another is that is the Citizenship Amendment Act, which is Dev Mukherjee versus Union of India. There are two cases are pending. Sir, as you may be aware, that the special rapporteur in the special rapporteur, her name, in both cases, the first case related with the deportation, Suleiman versus Union of India. Second case is the Citizenship Amendment Act, which was challenged by the Dev Mukherjee IFS retired. In both cases, what we see is new development like, we have right now former special rapporteur sitting with us. So a special rapporteur, in both cases, in one case, a special rapporteur requested for to intervene in the matter which is pending before the Supreme Court of India. So a special rapporteur, she requested, her request was done, and then I have that also paper with me. So a special rapporteur applicant, her name is E. Dentoi Echume. She was the fifth special rapporteur on contemporary forms of racism, racial discrimination, xenophobia, and related intolerance. So she wrote to the Supreme Court, and what she said, that is interesting, and that puts us like little bit forces us to think how we can improve and what are the problems. They said the applicant's objective, she is saying my objective making this intervention is to assist this court by offering her expertise. So she said, I am expert in the international law and experience on the issue of state parties obligation under international law. So we have many international law, we have legal and treaty division, but she is saying the objective is that assist the court by offering her expertise and experience on the issue of state parties obligation under international law with regard to the prevention of racism. And then she says the most interesting and also confusing, I say, she says she is therefore uniquely qualified to make submission before the Honorable Court pertaining to India's international law and treaty obligation in relation to the deportation of Rohingya refugees. If a special rapporteur, we don't know the fate of this intervener, whether what happened, we don't know, but I don't think anything has happened so far, even government will not permit. But she is saying, so we are sitting in the Indian Society of International Law, and she is proclaiming that you don't have any Indian who understand international law. We have worked in the law commission, worked additional secretary, Ministry of External Affairs. But she proclaims that she is the only person who can teach us international law and educate the court about its objectives under the international law and its international obligation. That makes us a little bit angry and upset. When she is merely an associate professor. I take her biodata in some university in the United States, but she is preaching and she approached the court. The another development which is also shocking and disturbing is in the case of the and there is not the High Commissioner for Refugees. Here also this Mitchell Bachelet, she was the High Commissioner for Human Rights. Now she is no longer there. She also approached the court, and on similar grounds she said, I want to come. And we are qualified to discuss about India's obligation in this particular way. So these are the trends makes us to think that how to strengthen domestically, which is already there. I'm not saying that we are going to, but some way we have to convey the world strongly that we have adequate number of people who can teach international law, preach international law, and also advise and assist the court of India. So these are the challenges which we have before us, and I'm sure that this conference which has taken place and many speakers are already on the line to speak will throw more light on this and take this note which I have highlighted. With this, once again I thank Chairperson for giving me an opportunity. Thank you very much, Rasmi.
Thank you so much, sir, for your introductory remarks. In fact, you have set tone of the entire panel. Sir has referred that how effectively we are implementing international human rights, and plus he has also added the challenges which we are having pertaining to human rights. Now with this, I would like to request our next speaker. He will deliver keynote address. Dr. Kishore Singh. He is former United Nations Special Rapporteur on the rights to education.
Good afternoon to all of you. I'm very happy to be here with you and participate in this conference, which I think should allow us, on the basis of our reflection and exchange of ideas, to advance further the area which we are trying to discuss. In this case, the field of human rights, international human rights. Human rights law, as we all know, came into being in a revolutionary. The whole human rights concept was outcome of the crisis and more particularly revolutions, French Revolution, American War of Independence, later American Bill of Rights, and then Second World War, devastating effect on the world, and the emergence of United Nations system, and the particularly universal proclamation by United Nations General Assembly of the Universal Declaration of Human Rights, which lays moral foundation of the human rights system and expanding framework. So, and then this process developed, many more areas of human rights became reflected in international legally binding treaties, where laid down obligations for the states, like the first is, this International Covenant on Political and Civil Rights, International Covenant on Economic, Social and Cultural Rights, then different specific dimensions, rights of the women, of child, indigenous people, disabled, so on and so forth. These international, about 10 international human rights conventions lay down the framework. And this is expanding. So we see, since the adoption of Universal Declaration of Human Rights, expanding framework of human rights as such. But we also see, unfortunately, the growing cases of violation, lack of protection, effective protection of human rights. And today, for example, you can witness in various crises that world is facing, how human rights are being adversely affected, undermined, or even neglected. Like, for example, the increasing inequalities between states, among the people, both international and national level, fundamental principle of equality of opportunity in human rights law, but we also enshrined in our constitution. The question of poverty, as you know, the global inequalities report point out, the distribution of wealth and growing inequalities are a serious concern, and about 1/3 of the world population below poverty line is biggest affront to human rights in general. Similarly, we have climate crisis, we have displaced populations, and immigration, and various other crises which intensify the challenge before us to effectively ensure respect for human rights and their full implementation. Because of time, I would not like to go further, but just to say that because of this, the human rights agenda has come on top of the world. In forefront in international development agenda, as reflected by, for example, the 2020 United Nations General Assembly Resolution on Future We Want, where the target set aspirations of the whole of international community was tried to strive in direction that makes human rights living reality. And then MDD, you know it full well, but also the Sustainable Development Agenda proclaimed in the United Nations in September 2015 led emphasis, and I quote from the agenda, a world of universal respect for human rights. And then we have Secretary General of United Nations report on our common agenda on the occasion of 75th anniversary of United Nations system in 2021, where also he spoke about solidity, need for solidity, human welfare, and global commons, and how we should protect, and laying specifically emphasis on our common global agenda, new social context, etc., a starting point for our joint effort, our mainstream international community, all of us, to improve global governance together on foundations of trust, solidarity, and human rights. So human rights are emerging a major concern of international community, and this is because of the gross, massive violations, not only of individual rights and collectivities on account of the lack of democratic system, lack of effective rule of law, etc., but also the world crisis and particularly the situation of various conflicts among the states. And therefore, I think we need to look into, and this is my view for our consideration as part of this conference, as to what are the major trends today which are obstacles to human rights system protection, or which are, I would say, and that is what I believe, even in contradiction with human rights, inconsistent, and how we can confront. For example, today we see in the world unbridled neoliberal economy, market forces, with the motto, market disciplines states. And states, although they are the subject of international law, are nowhere in reality compared to huge, big transnational corporations and global agencies, companies, which are having very strong hold on economy, industry, growth, and which therefore operate purely from point of view of laissez-faire economic profit making without carrying in the least, if I can say so, for human rights. And therefore, the question of how we can confront at international level the neoliberal economy, which, and particularly which is I think detrimental to right to development as well as the human rights, how we can try to at least effectively regulate, minimize possible the harmful, deleterious effect of their operations at global level. And when I say this, for example, we can look at different areas of human rights. Let's talk, and that's my primary interest, I have been talking about it, education. In many developing countries, in spite of the fact that education is inalienable human rights of every boy and girl, the whole concept of human rights said that you are born, we are all born with it, and there's no question of begging the states, please give us this right, that right. And education is first and foremost, because it is a right which is indispensable, and I contributed reflections on elaboration of this right in the university system, which is indispensable for realization of all other human rights. And what system of this right to education we see in our country and in many other countries, the system is Vidya has become Vyapar. Education is growing in a growing magnitude, becoming flourishing business, edu-business. And that's something that is because the governments are not effectively, not only not regulating, but many of the political authorities in different countries, but unfortunately including in India, are collaborating with these private agencies to impose their system in a way that is a gross violation of right to education and right to development. Similarly, you take health, more or less comparable situation, private hospitals, absolutely lack of good regulations, and the COVID in India gives a very good example of what happened. Take right to work, there is hardly any effective labor law today where a where workers can defend their rights, lot of strikes here and there and revolutions and social unrest and disruption of social cohesion, etc. are results in which we witness as a mark of show of neoliberal economy. So I will not expand on these different areas as to how human rights are being affected by this, but just to point out, as I said in the beginning, that this poses fundamental challenge and big threat to the whole United Nations system and Indian constitutional system. Whole United Nations system is constructed around social justice, social progress for the benefit of all of humanity. Whole United Nations system. Development, peace, and justice are the key pillars. Indian constitution, preamble, social justice, economic, political. Where is the question of social justice? If you see the society today, as I referred to earlier, we come back to the report, to the situation of the increasing gap between the rich and poor, and the way poor are being marginalized and their human rights are being, because of this growing capitalism, violated in a manner which states are not in a position even to fully ensure the protection that they deserve. And this is related also to the concept of social, not social, I would say legal even, responsibility of the states to provide social services. For example, if you look into the provision of services, public services, most of them are being privatized, and the whole concept of welfare state is diminishing, whereas it is fundamental to realizing the objective of United Nations system and of our constitution. And again, the reports abound in saying how the welfare state is extremely important, I would say indispensable for the human rights. And therefore, the question is whether we can develop a new concept of human rights internationally as well as in our country, which will enable us to, in a very conceptual general manner, ensure the full respect of human rights through elimination of poverty, which is the goal one of the Sustainable Development Agenda, through reducing the inequality, through making essential services, education and health, also available to public as a human right, and water you talk, and other in the conference just a little while ago, and others. And this is extremely important for us if we want to effectively protect human rights. Now, what are the grounds on which we can do? The grounds are very clear. The very spirit of Universal Declaration of Human Rights is to promote the dignity, human dignity. All human beings are born equal, their worth, their whole worth and the personal respect that deserved for human rights should be ensured, etc., etc. These are the ideals which are laid down in the Universal Declaration of Human Rights. Therefore, I think, and I would conclude with these three, four remarks. First of all, what we need is to regulate the unbridled market forces in order to ensure that there is, on part of these big corporate sectors, not so much full unregulated scope as it is today, but they are regulated in some manner to conform to human rights system. In this, there are two developments at the international level which are important. One is, you know, the Human Rights Council has been trying for a number of years now to develop what they call guidelines for human rights and business, and it being more obligatory for, not being obligatory, but it being optional, facultative for business to try to combine, to respect the human rights system. But the more important factor now, today, is the new development since last few months, or what, and I also contributed to that initially, at the instance of Office of High Commissioner for Human Rights and UNESCO, a new thinking that we need to look at human rights in terms of economy. So economy and human rights is the latest thing that is being discussed. And this is very much in line with the Secretary General's agenda which I mentioned just now. So we have, for example, these grounds to try to develop a stronger framework regulatory which will allow us to make human rights system not sacrosanct, that is ideal and all that is dream, but at least something in reality which is not so grossly violated. And then I would also like to submit need, and that's I think of key importance, need for fostering human rights culture. Why human rights are not being respected? Why is it that human dignity, which provides sustenance to the whole system of human rights, is not fully respected in society, in our families? The reason is that there is not real human rights culture with which our community, our society is infused, and that we overlook, we do not look into, particularly we overlook the human rights violation. And therefore there is need, in my view, to try to promote a human rights culture in which the human rights system becomes integral to a person's belief, faith, approach towards life, and therefore it is something which will strengthen the cause for protecting human rights effectively. And in this, we can, for example, and we should build more on the Universal Declaration of Human Rights, which stipulates as regards human dignity, that all human beings are born free and equal in dignity and right. They are endowed with reason and conscience and should act towards one another in the spirit of universal brotherhood. And this, in Article 1 of the Human Rights, of Universal Declaration of Human Rights, this provision is very much reflected in our Indian spirit heritage, because India also is very strongly founded on universal brotherhood. We hear a lot on Vasudhaiva Kutumbakam and other concepts which are being propagated. But the gist of Vasudhaiva Kutumbakam is that the whole earth, as a mother earth, is our family, and we all humanity is the one family, and that concept is something, if that is accepted, then we will have a culture of human rights. But then, and that is another point which is of my deep concern, I've been talking about it, that today we are witnessing a crisis of value crisis. I talked on it strong, just 2 minutes. Yeah, I am concentrating to it. And therefore, what we need to do is to try through education system to inculcate in children and youth human rights values and values of ethics, of moral education, so that they also become not only defenders of human rights, but full human beings in their own right. And lastly, and that is to conclude, we must come back to the concept of symbiosis between human rights and human duties, because there has been too much focus on human rights. But as Gandhi said at the adoption of the Universal Declaration of Human Rights, that he believes more in duties than in rights. We have to, and this is in keeping with our Part 4 of the Constitution, we have to come back to the concept of human duty in tandem with human rights in order to foster full protection of human rights. So with this, I will thank you very much for the opportunity, and I do hope that this conference will try, in conclusion, to raise these fundamental questions of why human rights are violated and how we can try to promote them further. Thank you, and sorry for having taken more time.
Thank you so much, sir. Mr. Kishore Singh, who was Special Rapporteur for Right to Education, his work on right to education we all refer on and often. In his speech, today he has highlighted a relationship which we are required to understand between the economy and human rights. And further, he has suggested also that we should promote human rights culture. So thank you so much, sir, for your worthy words. Now with this, let's start with all the presentations of our guests, of our speakers. So let me start with Mr. Dinesh Tripathi. I would like to request all the speakers that kindly take 7 minutes so that we can have some time for will follow the order.
Thank you so much. It is pleasure to be here. I'm very thankful to the organizer that they invited me here in this conference and gave me opportunity to speak. And the topic is about human rights in the global order. There is an emerging global order and the place of human rights in this changing scenario. So people all over the world, they are struggling for their rights. So it's a global war is taking place all over the world. And I would say that human right, justice, rule of law, not only a prerogative of rich country, an industrialized world. It is a universal notion. So people, any part of the world, they entitled to their freedom, their right, and their dignity. Human right is all about to protecting and promoting the dignity of human person. The role of the state, the primary role of the state is also protecting the dignity of human person. The primary role of democracy is also about promoting and protecting the dignity of human person. So we are living in a very interesting time in human history, particularly after the Second World War. There is a tremendous growth of international law. So international law is growing, and at the same time, international human rights law is also growing. United Nations, it adopted Universal Declaration of Human Rights. It is a soft law, it has no teeth to implement it, but now it has become the part of customary international law. So there is no matter of ratification, but the Universal Declaration is there, and all the nation state, because under the Article 55 and 56, all the member states of the United Nations, they taken a legal duty. They promise that they will protect and promote human rights in a collective manner, and they will also aspire for a global system for human rights. So after that, global community realized that UDHR has no legal teeth. It has no enforcing mechanism. Then the binding treaty has been also adopted, and ICCPR, International Covenant on Civil and Political Rights, and International Covenant on Economic, Social and Cultural Rights was also adopted. And large number of the nation, member states, they have adopted it. They domesticated it. And all over the world, the lawmakers and constitution makers, they have been inspired by International Bill of Human Rights. The UDHR, International ICCPR, and Economic, Social and Cultural Rights, Covenant on Economic, Social and Cultural Rights. It constitutes International Bill of Human Rights. So we are under the global regime. We are, there is a notion that pacta sunt servanda. So in the good faith, we have to implement and enforce the human right. So human right is critically important. So the protection and promotion of human right provide the very legitimacy of the state. If the state violate the rights of their citizen, if the state take away the rights of its citizen, the state lose its legitimacy to rule. And then people have right to revolt against the tyrannical government. So because, the protection of rule of law, the basic, the foundation of nation state. So state is under duty to protect and promote the fundamental rights of its citizen, human right of its citizen. And no state is allowed to violate the rights of the citizen. But there is a big gulf, there is a huge gulf between reality and idealism. So gross violation of human rights is taking place all over the world. There is a war. War is the biggest violation of human rights. Poverty is the biggest violation of human rights. And there is a growing global inequality. More than 90% of the global resource is consumed by only 10% of the population. So it's a big, huge injustice. Even the international order is also undemocratic. The UN is also undemocratic organization which talk about human rights. It sponsored the large number of human rights laws and treaties.
But the very structure of the United Nations is also undemocratic. There are certain members, they have a veto power. They are more equal than others. And developing country, poor country has a very little voice in the global arena. First, in order to have a rule-based global order, in order to have human right-based global order, we have to also democratize the international order. We have to also democratize the United Nations. And there is a violation of laws of war, laws and custom of the war. The small nations are under threat. The poor nations are under threat. So violation is taking place. So,
Tripathi sir, can you finish in one?
okay. So it's not only the law and constitution is important, but you have to also build the culture of human rights. We have also built the culture of democracy. So that's why, because the state, there is a general tendency to that their state has become tyrannical. There is a sinking space for democracy. There is a sinking space for freedom in every part of the world. And now there is a very weak enforcement mechanism at the International Human Rights Treaty. There are some regional mechanism is there, like European Court of Human Rights is there. It's like a success story. There is African state has also a regional body. American Inter-American state has also a regional court of human rights. But we, South Asia, is also lagging behind. We don't have any regional mechanism. Since many years, we are also talking about to having some kind of regional mechanism at South Asia level. So regional mechanism could be also effective mechanism. So we can also work for that. So thing is that how you can promote rule-based global order, rule-based national order, so that under the framework of rule of law, the culture of human rights can grow. Thank you so much.
Thank you so much, sir. Thank you so much. So, in his address, Mr. Dinesh Tripathi, who is a senior advocate in Nepal, so he emphasized on rule-based global order. Now, with this, I would like to invite next speaker, Mr. Anshul Saxena. He has written paper along with Professor Dr. Vaibhav Goel. His paper is on protection of human rights, central role of United Nations General Assembly. So, Mr. Anshul Saxena. Mr. Saxena, you can start. Okay, so if you have some time, then can we have? Yeah. So let's have next speaker. By that time, let's arrange your paper. Yes, I would like to invite Professor Dr. Vijay Kumar Verma, Dayal Singh College, Delhi University. He is going to speak on Universal Declaration of Human Rights, its scope and.
Respected chair, respected co-panelist, and dear august audience. Let me have a brief introduction of mine only. I am a teacher. I teach political science at Dayal Singh College, Delhi University. By training, I am a student of political science only, though I have done law from DU also. So my input would be, quite different. It is not going to be very legal in, interpretation and all that. See, we have a paper called Human Right in Comparative Perspective. I have been teaching that paper, and we teach all that is being discussed, all details, UDHR, all articles, spread, preamble. I did law, we did two paper on constitutional law, so all things related with all goody things that is there, we have done it. But as a student of political science, I have some, original problems in interpreting the things and looking at it from a very different perspective. And since I have the habit of being bilingual in the class, I may shift off and on to Hindi and English, so please excuse me for that. See, as a teacher of political science or as a student of political science, I have personally always observed that every relation in this world is a power relation and relation of interest. For an individual, it is personal interest. For a nation, it is national interest. I interpret the whole world, everything that is beneath the sun, 95% of that, I look at all that from that perspective only. Well, I would be very simple in my presentation, and let me share two, three very small stories with you. एक कुआं है, एक तालाब है, वहाँ काफ़ी सारे फ्रॉग हैं, and the boys, they are targeting with stones. And the headman of the frog, he comes and says, "Why you are killing us? तुम हमें क्यों मार रहे हो?" And the boys, very innocently, they say, "We are not killing you, we are playing." And the headman of the frog says, that is very remarkable sentence, "What is a play for you is a date for us." जो तुम्हारे लिए खेल है, हमारे लिए मौत है. When I see at any issues at national or international level that has ultimately culminated into war or conflict or any clash, I believe for many it's a play. And for the victims, it's worse than death. You can put it in Ukraine-Russian crisis context. You can put it in context of Afghanistan. I wonder, as a student of political science, I have written two books, Chairperson ma'am, on UN also. One is published by Orient Black Swan, other by Pinnacle. One is in Hindi and other in English. But I fail to understand, when these crises are there, where is UN? When my student, they ask me a very simple question. They said, "Do you think finally UN has failed or succeed?" I think, I don't have a very simple answer. All I can say, or I managed to say is so far, the highest contribution of UN is that since 1945, when it was formed, till date, we have not entered into third world scenario, though many times it appeared that third world war is going to be very nearby. Apart from that, I think it's very difficult. Even nowadays, when you think of Ukraine-Russian crisis, if you watch newspaper, media, social media, or mainstream media, or if you go through newspaper, we fail to understand that there are more news about USA or about UN related with Ukraine-Russian crisis. So it's very problematic. In later and the spirit fine, that's UDHR may be an excellent document possible under the sun, no doubt about it. No doubt. I've gone through all the articles because I have to explain it to my student. But when I look into the execution part, I feel very sorry for the victims, And I think in the larger scenario that every relation is a power relation. I will quote one international thinker, Kenneth Waltz. He said, "We are living in a world," he's a neo-realist thinker, and he says, "We are living in a world of self-help." जैसे बस में लिखा रहता ना, यात्री अपने सामान की रक्षा स्वयं करें. Nobody is going to take care of you, even as an individual, as a nation. And that's why at one, on one side we can talk of peace and international world order, new global order, justice, global justice, everything. But at the same time, we live in an anarchical world. Nobody can guarantee your security. And ultimately you see that every state is aspiring for being a nuclear power. Yeah, just a minute. So when I look at Kenneth Waltz, again finally, though I may sound very crude and rough, but I am sorry to say we live in a world where power relation matters. Even in one-to-one relationship, community-to-community relationship, nation-to-nation relationship. It's not a question of who looks for peace. For many, war may be a business. I was going through one article that says that even in Russian-Ukrainian crisis, neither Russia is the gainer nor Ukraine is the gainer, but armament industry is certainly the biggest gainer. So that is the thing. I think let us talk from very realistic perspective. It's good to be theoretical, good, not bad to cite the provisions. That is always very inspirational. I will conclude my last statement agreeing with Kishore sir. He just said that certainly US has been successful in many cases, but we find massive cases of violation of human rights across the world, within the country, outside the world. It seems as if the whole globe is on fire. Thank you.
Thank you so much, Professor Dr. Vivek Kumar Verma. May I now request our next speaker, Mr. Anshu Saxena. He is a PhD scholar and he is going to present on protection of human rights, central role of United Nations. I hope your PPT is ready now. So just now, our earlier speaker, Professor Dr. Vivek Kumar Verma, his paper's title is that was UDHR. So we all know that now we are celebrating 75th year of Universal Declaration of Human Rights. So let's see that what our next speaker is putting forward in this paper. So Anshu, you have 5 minutes.
Good evening, very good evening to all of you. My topic is protection of human rights, and we will be looking at how United Nations General Assembly plays a central role in protection of human rights. So just to give you an overview, if we look at the UN Charter on Human Rights, we all know UN Charter basically has two overarching principles. One is state sovereignty, principle of non-intervention under Article 2, Clause 4, and other is protection of human rights. Now, most of the time, these two principles or values stand in direct contradiction to each other, because to protect human rights, sometimes there is no alternative but to invade, or not invade, but to contravene sovereignty of another nation. So, many times it happens that there is some clash between these two values. However, in this paper, we will be not looking at that aspect, but one of the core principle of the Charter, which is the human rights. Now, if we look at the language of the Charter, in the preamble of the Charter, in Article 1, which lists down the objectives of the Charter, both says that one of the most fundamental objectives with which UN Charter was drafted was protection and promotion of various fundamental human rights. As we can say, the Charter preamble itself talks about reaffirming faith in fundamental human rights and dignity and worth of the human person. And same is the Article 1, which in one of the clauses says the purpose of the Charter is protection and promotion of human rights. Now, moving forward, now if we look at the main topic, focus of this topic of UNGA and human rights. So, UNGA adopted UDHR in 1948. Now, speaker just before me or before him said the UDHR is not a legally binding document. No doubt it is correct that it is not a legally binding document. But if we look at what happened since the adoption of UDHR, this document has been translated into 500 languages. This document finds it mentioned in more than 70 human rights treaties, and more so it changed the way we look at various human rights. For example, it was the first legal document which recognized under Article 26 that right to education is a fundamental human right. Before that, earlier what happened was, we used to think of education is a privilege, not a human right. But after UDHR, for a right to education was treated as a fundamental human right. Similarly, there are many other rights which, since the adoption of UDHR, changed the thinking about that, and most of the nations which got freedom after that incorporated rights given in the UDHR in their constitution. So in that sense, even though it is not legally binding, but still it somehow made its way into other legally binding documents. Then we say other resolution which UNGA adopted was ICCPI 1966 and ICE-SCR. Then UNGA also established United Nations Human Rights Council in 2006. Then moving forward, then in some other examples, for example, UNGA adopted Convention on Elimination of All Forms of Discrimination Against Women in 1979. It established various mechanisms for protecting and promoting rights of vulnerable groups like children, refugees, and persons with disabilities. As you can see in the last point, the Convention on the Rights of Child was adopted in 1989, which sets about right of children, including right to education, health, protection from violence, abuse, and exploitation. Then it has also adopted various resolutions which aims at protecting right of refugees and displaced persons. This is especially relevant in today's context in the light of Rohingya refugees or in Russia-Ukraine war, when the Ukrainian refugees are moving in all different countries. And as I already told you earlier, UNGA also promoted right to education. So moving on. Now, no doubt that UNGA has adopted various mechanisms, resolutions, and documents which protects human rights. But if we are to think that work has been done, then that is absolutely not true. Still a lot has to be done. And what I mean by this is, even though we have various documents which talk about human rights, all its nuances, and how it is important, but point is, whenever there is a international conflict that takes place, any conflict situation, for example, just recently Russia-Ukraine war that has been going on for last 1 year, or the Israel-Palestine conflict, or the Syrian conflict, in all these conflict situations, the most heinous and grave human rights violations take place. You can have all the documents, all the resolution talking about human rights, but at the ground, that person does not get any benefit from that resolution, because his most or her most fundamental human right to life and liberty is also not protected in that situation. There is such a blatant violation of human rights. So what we feel is, unless this maintenance of international peace and security is not taken care of, the enforcement or protection of human rights cannot be achieved. For example, I can give you some statistics, but just to not sound insensitive, while these are statistics, but these are all real people that died in these conflicts. For example, World War II, just before United Nations Charter was drafted, somewhere 70 to 85 people lost their lives, with majority of them is civilians. India, which was not
Mr.
readily...
Anshin, please come on your findings and your suggestions.
So, okay, the way forward, we'll discuss. The authors here think that there can be 2 or 3 ways in which this that the UNSC does not work because of the abuse of veto power. So how do we maintain international peace and security? So what the authors feel is, either you can, what are the solutions for this? That you can bypass, or you can somehow move forward from this deadlock in the United Nations Security Council. Either you have the amendment of the Charter under Article 108, but that itself will not happen because that process will itself be vetoed by one of the permanent member. So that will be like moving in circles. So what is the other option? Other option is that you go for the purposive interpretation of the Charter and not the literal interpretation. What I mean by purposive interpretation is that you look at the language that the Charter employs, and you see that the Charter wants that there should be protection and promotion of fundamental human rights, especially if we read Article 55 with Article 56, which asks all member states to cooperate with the UN to protect and promote fundamental human rights. But the problem is, even if we go by purposive interpretation, the language used in Article 24, Article 41, Article 12, it's so express that no legal jurist would be able to defend the purposive interpretation in that sense also. So there is one solution that may sound radical because it may not find support in law, but there can be a case where a UNGA passes a resolution in case of an international conflict and uses armed force to calm down the situation. And even if there is a veto by United Nations Security Council, still United Nations General Assembly should go forward and enforce that resolution. What this can do is that once UNGA has acted despite the veto by the United Nations Security Council, then going by the principle that subsequent practice can change the way in which treaty is to be read, or in some cases even a modification can be said to have been had to the treaty. So in that case, if UN General Assembly acts despite UNSC veto, we, the legal jurists or the ICJ can in that sense say that the subsequent practice has changed the way in which the United Nations Charter is to be interpreted, and in case of serious international conflicts to maintain international peace and security, United Nations General Assembly, being the sole authority to have the reserve power, can act. Because after all, what is the use of having UN Charter or these UNSC resolutions or UNJ resolutions if during the time of international conflicts, the international community cannot protect the most basic fundamental rights of men and women who are there in the conflict. After all, कानून इंसान के लिए बनाए ना कि इंसान कानून के लिए बनाए. Thank you.
Thank you so much. Thank you so much, Mr. Anshul. And now let's move to the next. She is Ms. Shritha K. Vasudevan, and she is going to speak on Article 5A of CETA. So human rights are for all, and we will find that there are human rights conventions for women, children, refugees, etc. So she is going to highlight on Article 5A of CETA. Yes. So Ms. Shritha, you have 5 minutes.
I really want to thank the Indian Society for International Law for giving me this opportunity to be present here. So the argument that I'm going to make is, first of the research question that I'm dealing with is, what has caused the government of India to accede to the CEDAW by stating, that it will only implement Article 5A when it does not require interference in the personal affairs of all its religious communities. Now, all I'm arguing is that, drawing from what Professor B.C. Nirmal said in the opening plenary, the important question that we as international lawyers and scholars of international relations are always grappling with is whether international law is actually relevant to state practice. And so, what I'm trying to show is that in this case, it seems like India's declaration is apparently an epiphenomenal, to the international realm. India has just stated that it will not implement Article 5A of the CEDAW, but on the contrary, it can be proved theoretically that India's declaration was actually path dependent on 2 historical moments in Indian history, and that India has accorded the international gender norm the exact same sanctity that it has accorded these events, it has accorded the international gender norm under its domestic constitution. The argument very simply is just this. We have a conflict between the right to freedom of religion and the right to gender-based equality under Article 14, 15 and Article 25, which has seen extensive expositions, in the Sabarimala and Triple Talaq judgments. And all I'm saying in this paper is that you can just look back into India's history and understand the reasons for India's declaration in the Sati of Roop Kanwar and the Shahbanu judgment. So I'm going to use the theory of Professor Hans Morgenthau and Professor Alexander Wendt to make my case. And thereby, I'm going to bring a gender discourse, to international law in the hope and expectation that India can actually play a greater role in articulating its gender experience on an international world stage. So what is the focus of my research puzzle? The fact is that Article 5A has attracted the greatest number of reservations to any human rights treaty ever. So the CEDAW has this notorious distinction. And then India's declaration stating that it will only liminally interfere in the religious affairs of all its communities, just makes the case that India pays scant regard to this norm, in the international realm of gender, affairs. So is India's declaration reflective of Hobbesian anarchy? In other words, is India just saying that we don't really care about the international gender norm? I'm actually saying no, that India's declaration can be located in its material history. So what is path dependence theory? It says that what happened at an earlier time is going to affect later events, and that small steps taken by governmental actors is going to lock in subsequent events. And then what does Hans Morgenthau say in relation to my theory on India's declaration? He argues that the state is a rational actor, and I'm arguing that India has actually rationally responded to the international realm. And then governments make decisions on a rational basis motivated by domestic considerations. So basically, India's declaration was path dependent on Roop Kanwar Sati and the Shahbanu judgment. and that behavioral repetitions are common to human behavior. This ties into power dependence. The state, when confronted, with the international gender norm under the CEDAW, behaved in the exact same way it has behaved in the case of Rup Kanwar judgment Rup Kanwar Sati and Shabanu judgment. So power is directly dependent on the political and cultural environment. It's not solely material. It's not solely all to do, with armed power. So I'm peering into India's immediate past. So Morgenthau's famously said that morality does not matter to India's politics. But however, I have shown in this paper that India is confronted with the same dilemma under its domestic constitution and then has responded in the exact same way to the international gender norm. So it was structured. So when India acceded to the CEDAW, it was structured into its image of the international norm was structured by its domestic experience. So, and India has superimposed its own constitutional experience onto the international sphere. India, if I can borrow from Wendt early on, states it has actually constituted the international condition of patriarchal anarchy. Now, so I'm just going to another seminal scholar in international relations, Alexander Wendt. He says that shared ideas determine international politics, and identities and interests of purposive actors are constructed by shared actors. So I am basically saying that India has So I'm basically saying that these two moments are diagnostic pieces of evidence, and Rup Kanwar was an 18-year-old Hindu widow who was burned on the death of her husband in 1987. India was confronted with a lot of societal consternation despite a governmental ban. 8 lakh people gathered at the and then it was the public nature of Rup Sati despite Supreme Court ban orders and governmental ban orders. And the government passed legislation in accordance with the Constitution of India. In the case of Shabanu, she was a Muslim divorcee. She was divorced after 44 years of marriage by her husband. And, and the Supreme Court and Justice Chandrachud granted her a marginal alimony of $40 per month. And of course, this was reversed by the Parliament of India. And basically, what happened was the Indian government was confronted with the conflict between the right to freedom of religion and the right against gender-based violence. And therefore, my argument is that the international gender norm is not every phenomenon to the Indian state interest. It derives inherently from the Indian historical experience. And so the conceptual framework of the international gender norm is actually valid to a state, and we have to take it and enforce it further, in a domestic and international space.
Thank you so much, Ms. Shritha. So Ms. Shritha, she highlighted various issues including fatigue, gender-based violence, and many others. So thank you so much for your inputs. And may I now call the next speaker. He is Advocate Dr. Suripalli Prashant. He is doctor and also a practicing advocate in Telangana and Andhra Pradesh High Court. He is going to speak on the rule of advice in international human rights analysis. You have 5 minutes.
So I am talking about the rule of advice in international human rights law, wherein my primary focus would be on international courts that have advisory jurisdiction and deal with human rights. So I am focusing on the ICJ, Inter-American Court of Human Rights, and the European Court of Human Rights in my presentation. Under the predecessor to the ICJ, the Permanent Court of ICJ, that is only organs representing the states could ask for advisory opinions, but some changes under the UN Charter, including extending the right of the General Assembly to grant advisory opinions to other organs of the United Nations, brought in the expanded the scope of advisory jurisdiction. And the advisory jurisdiction as far as ICJ is concerned stems from Articles 96 of the UN Charter and 65 of the Statute of the ICJ. And despite the lack of an explicit restriction under Article 96, Paragraph 1, the ICJ should not accept cases where any organ is acting outside its jurisdiction, and the ICJ statute also provides with discretionary power, allowing it to decline to give advisory opinion. So here, several organs are authorized by the Charter to submit advisory opinion requests before the ICJ. and of these organs, the UN Security Council and the UN General Assembly hold a blanket ability to submit a request on any legal question. How is the advisory jurisdiction of the ICJ exercised? There are three reasons, three aspects. The request must be made by an authorized organ of the UN, and the request falls within the scope of the organ's activities is number 2, and that is in case of organs different from UN General Assembly and Security Council, and the question asked must be a legal question. So the UN General Assembly could submit a request for an advisory opinion in comparison to other UN organs, but it would, for instance, not face the barrier of a veto, which would make it challenging for Security Council to submit a request before the ICJ. Additionally, in the case of legal consequences of the construction of a wall in the occupied Palestinian territory, the political question had arisen before the ICJ, but the ICJ held that it does not deprive it of its legal character. The court has established that the political nature of the motives which may have said to have inspired the request and the political implications the opinion given might have no relevance in the establishment of its jurisdiction to give such an opinion. That was held in the case of legality of the use by a state of nuclear weapons in armed conflict. And now coming to European Court of Human Rights, compared to the ICJ and the Inter-American Court of Human Rights, the European Court of Human Rights has limited jurisdiction. The European Court of Human Rights may only give advisory opinion on legal questions concerning the interpretation of European Convention and protocols thereto. And in 2018, the European Court of Human Rights issued its first advisory opinion requested by the French Court of Cassation concerning the recognition in domestic law of a legal parent-child relationship between a child born through gestational surrogacy arrangement abroad and the intended mother. Then in May 2020, the court delivered its second advisory opinion under the newly established advisory power on the use of blanket reference or legislation by reference. Then coming to the Inter-American Court of Human Rights, the Inter-American Court of Human Rights has competence with respect to matters relating to the fulfillment of the commitments made by states party to the convention under paragraphs 1 and 2 of Article 64 of the Organization of American States Statute. The party has an absolute request to ask for an advisory opinion. And the jurisdiction of the Inter-American Court of Human Rights covers questions regarding interpretation of American Convention Article 64 paragraph 1, questions relating to interpretation of other treaties concerning protection of human rights in the American states under Article 64 paragraph 1, and whether requests pertaining to whether a state's domestic laws are compatible with the American Convention or other treaties. The Inter-American Court of Human Rights has broad jurisdiction, and some states have argued that the Inter-American Commission should not be allowed to ask for advisory opinions on states' domestic laws. And in 2021, the Inter-American Court of Human Rights broke ground by issuing an advisory opinion saying same-sex marriage is a fundamental right under international law, making it the first international tribunal to render such a decision. So the Inter-American Court, compared to the ICJ and the European Court of Human Rights, the Inter-American Court of Human Rights is the most active in protecting human rights vis-a-vis rendering advisory rulings. And as of April 2021, for some statistics, Inter-American Court of Human Rights has issued 26 advisory opinions. The International Court of Justice has issued 28, and the International Tribunal for Law of Sea has issued 2, and the European Court of Human Rights has issued 3. So, the Inter-American, there is a difference. The 2 minutes. The difference between contentious adjudication and advisory jurisdiction, the key principle that governs contentious jurisdiction and advisory jurisdiction is that states may not be brought before an international court unless they have consented, whereas courts acting under contentious whereas courts acting under advisory jurisdiction may anticipate that they can submit to international dispute mechanism and anticipate that a judicial outcome will favor their position. They will presumably submit to such mechanism. courts acting under compulsory jurisdiction must treat states with particular care that courts deal with sovereign equals which set up the existing legal proceedings, legal process present in which they are concerned. And I would conclude by saying that human rights courts are of significant attention to scholars, but most of the well-deserved attention focuses on contentious jurisdiction despite the prevalent exercise by human rights courts of their advisory powers. And the notion that advisory jurisdiction is simply a non-binding use of jurisdiction needs significant qualification, and the ICJ's opinion in construction of wall in Palestine and the Inter-American Court of Human Rights ruling in consular relations on right of undocumented migrants reflect an elevation of individual rights over state rights. And the courts should also use discretion, that is the international courts, in accepting advisory opinion requests, especially by monitoring which state or entity is requesting the opinion. And the court should also pay attention to domestic courts and how they are responding to similar issues. So this could remove the criticism that advisory practice and opinions are rendered more effective for the oral enjoyment of human rights, and advisory opinions could thus be more than a Pyrrhic victory. Thank you. I thank the chair and the organizers for giving me this opportunity.
Thank you so much, Dr. Suratali Prashant. Now, I would like to call Dr. Snehal Fadnavis, Principal of GWCL, and she is going to speak on future of economic, social, and cultural rights in the era of global technological advancement. Over to you.
Good evening, everyone. Honorable Chair and respected co-panelists and all the delegates present over here. Today we are deliberating. Yes, no. Today we are deliberating about the international law and changing global trends. Much has been talked about future of international law as well. We see now everything is globalized and it is established beyond doubt that we cannot survive without international law, because everything is linked to international law these days. We have witnessed pandemic for last 3-4 years. We have witnessed the Ukrainian crisis. We are witnessing the disasters like earthquakes, floods, climate change, wars and internal disturbances. So all have greater impact on human beings, human society, and ultimately on states. I have written paper on future of economic, social and cultural rights in the era of global trends, global technological advances. We are talking about global trends. So one of the major trend is the technological advancement, which is causing impact on human rights and the lives of individuals. We are talking about social, economic and cultural rights since last 75 years. So you may have a question why there is a need to talk about social and economic and cultural rights in this conference. But the time has come to see that we have to think twice about these rights. Under international human rights law, as well as in terms of its application at the national level, civil and political rights have in many respects received more attention, legal codification and judicial interpretation, and have been instilled in public consciousness to a far greater degree than ESC rights. Economic, social and cultural rights are often viewed as effectively second-class right or second-generation rights, unenforceable, non-justiciable and only to be fulfilled progressively over the time. So in such perspective, however, we overlook a postulate of global human rights system formulated as long ago as in 1948 with the adoption of the Universal Declaration of Human Rights, namely that indivisibility and interdependence of civil and political rights and economic, social and cultural rights are fundamental tenets of international human rights law. In fact, they supplement and complement each other. Socio-economic rights are those human rights that aim to secure for all members of a particular society a basic quality of life in terms of food, water, shelter, education, health care and housing. Uh, uh, we are living in the era of technological advancements, particularly after pandemic. The entire world have moved towards digitalization. Everything is digitalized, like from banking, teaching, meetings, conferences, even court matters were conducted through the technology. However, there are pros and cons of this technology. It is very helpful, no doubt about that, but at the same time, it is harmful and it has some good and some bad effects on human beings and on human society. From practical point of view, technology is helpful for moving the agenda of human rights forward. For example, the use of satellite data can monitor the flow of displaced people. Artificial intelligence can assist with image recognition to gather data on abuses of rights, and the use of forensic technology can be used in investigation of crime and catch hold of the perpetrators. However, in many areas in which emerging technological advances, the human rights agenda, technological developments have equal capacity to undermine the efforts. Due to technological advancement at global level, the world is certainly going to be changed. It would be more urban and better educated and better connected through information and individually get more empowered. In this situation, the government faced more challenges such as security concerns and scarcity of natural resources. Such situations will obviously have many consequences for the protection of human rights, some evenly positive such as increased education levels and some negative such as scarcity of natural resources, which is gloomier side of the technological advancement. I have, for lack of time, I have highlighted very few aspects of it which are more impacted. First is food security. Because of the population is growing very fast and the increase in life expectancy also increases the risk of almost doubling of population. So there will be the scarcity of food, and the water scarcity will also be there, and which would be another major issue. There would be question of safe drinking water, particularly in slums and in rural areas. Another is education, which is the education level of the people would be very high. We can evidence the more literate society, and nation impact positively on social and economic outcomes. People will be more aware about their rights and perhaps better equipped to claim and defend them. Another aspect is migration. Issue will be there. People will migrate from one place to another. Then security issues are there, environment issues are there. The major issue is the climate change. In view of all these technological advancements, there are many advantages of technological development that lead to growth of economies, made conducting business and personal communication easier, fostered globalization. However, it is important to consider the dangers of this concept in connection to the issue of human rights. This is only a partial look and what would be the future of ESC rights, ignoring a large area of concern, but even a number of important issues that might that ought to be considered by human rights organizations when formulating the plans for future work. With this, I conclude, and I am very thankful to the organizers for giving me this great opportunity Thank you so much.
Thank you so much. Thank you so much, ma'am. Now, our next speaker is Dr. Balaji Naika. She is assistant professor in DU and she is going to speak on protection. He is going to speak on protection of human rights and existing mechanism in the Asian region. A critical aspect. You have time. Last.
Okay. So,
After
respected
the speaker,
chair.
we will take questions. So, all of you, you please be ready with your questions.
Respected chair, fellow panelists, and dear friends. So, keeping in mind the human rights of panelists as well as the audience, I will finish in 3 to 4 minutes. So, so the topic of my today presentation is the protection of human rights and so the existing mechanism in Asian region. So, when you talk about the human rights are most important because the important agenda of or the mandate of United Nations is to protect the human rights. And also the human rights plays a very important role in the international politics. So when you talk about the protection of human rights, there are 3 stages we have to discuss. The first one is the international level, second is regional level, and the third one is national level. So when you talk about the international level, we have a strong international legal mechanism as well as the institutional mechanism. So we have starting from UDHR, you have a covenant, we have a range of international human rights treaties. And also we have a institutional mechanism ranging from the UNHCR, many other human rights treaty, institutions. But when we talk about the regional mechanism, that is where my focus in this presentation is. There are the 4 main regions we have to discuss. The first one is the American region, European region, African region, and Asian region. So when you look at the different regions, so take the example of American region, we have a strong, the norms and institutions are established, whether it is American Convention on Human Rights, American Code of Human Rights, and American Commission on Human Rights. Likewise, we have a similar legal and institutional mechanisms are established in European region as well as the African regions. So in Africa, we have African Charter of Human Rights, African Convention on People's Human Rights, African Code of Human Rights we have. But when you come to the Asian region, so we don't have any regional mechanism. Why it is important to discuss about Asia? Because there are a lot of human rights violations are taking place in Asia, but at the same time, we don't have any regional conventions. So the reason why, so the question normally arises, why there are no human rights mechanism at the Asian region? So there are 3 important reasons the scholars highlighted why we don't have a regional convention in Asia. So the first one is the debate on the Asian value versus the universalism. The second reason is what we call the state sovereignty, the non-interference, the principle of non-interference. The third reason is the inadequacy of the lack of signing to the international human rights treaties by the different countries in the Asian region. So these are the 3 reasons why we don't have a regional mechanism in Asia. Let's take this one by one. So the first reason is the Asian value. The Asian scholars, starting from the 1955 Bandung Conference to the 1993, the Vienna Convention, Vienna Congress. So in all these places, the Asian scholars try to highlight how the Asian value is different from the Western values, how we protect human rights and how the Western nation talks about human rights. These are 2 different. So that's why we don't concern about what the international human rights, Western human rights scholar says. That is one reason why the Asian region does not have a regional mechanism like the international, like in the Europe and America. The second reason is the Asian scholars strongly argue that the principle of non-interference. So in the name of human rights, we know that the Western organization or the imperialism started with in the name of human rights. In order to protect the human rights, we have seen large-scale violation of human rights by the Western institutions. So that's why the Asian scholars' argument is, so because of these reasons, we don't want a regional mechanism like we have in the Western countries. The third reason is, the inadequacy of the signing the international human rights treaties. Take the example of Refugee Convention, 1951. How many countries are party to the Refugee Convention in Asia? Very, very few. India is also not party to the 1951 convention. So because of three reasons, we lack effective regional mechanism in the Asian region. So despite of that, if you look at the Asian region, so we have sub-regional mechanism. The SARC also adopted some of the legal mechanism as well, the law SARC Charter, as well as the ASEAN also has a few declaration on human rights. So with this, I would like to conclude that. So in the 21st century, in the modern era, since there is a large-scale violation of human rights are taking place in Asia, so let's take the example of refugee or displacement. So we don't have any regional mechanism. We don't have even a national legislation on these the categories. So that's why it is important. It is high time that the Asia must have a strong regional mechanism, like the Asian Convention on Human Rights, Asian Commission on Human Rights, and Asian Code of Human Rights. So with this, I would like to conclude this and thank the organizer for this opportunity.
Thank you so much, Dr. Balaji Naika. So with this, as the scope of human rights is very vast, so my panel was very vast. But however, because of the cooperation with all the panelists, yes, we are not on time, but only 10 minutes we are late. So once again, thank you so much. I would like to thank Mr. Manoj, Dr. Kishore Singh, and all the panelists. With this, I would like to open for the question answer.
I think the focus has to be on implementation. The actual availability of the human rights to the vast people. And for this purpose, I think that the human six levels. The question hurdle.
Thank you so much for your comment. Any question, any comment? So, so once again, let me thank. The area of human rights is very progressive in nature, and we will see that yes, the awareness is growing day by day. We have started our journey of human rights with rights of individuals. Now we are discussing on even the rights of robots as well. So this particular journey, we all are witnessing. However, at the end of the day, as one of the speaker and one of yes, also he has pointed out that ultimately it is all about the compliance, all about the implementation. And as our keynote speaker, he also said that we are required to develop human rights culture. We are required to promote human rights culture. In addition to that, we are required to inculcate the culture of the dutifulness also, or that adherence amongst all the citizens as well. So then only we will be able to have realization of human rights in true sense. In 1993, in second World Conference on Human Rights, they have adopted Vienna Action Plan, and after that we have seen remarkable development in the area of human rights. In fact, in India also we have adopted Protection of Human Rights Act 1993. So however, we all of us, we are required to keep in mind that yes, we are required to move ahead. As technological advancements are enormous, so therefore misuse may also be there. So therefore, we all, the researchers and the students of international law and international human rights, we are required to take care that the fabric of this society must not be disturbed because of the technological advancements and we must be able to protect and promote humans. So with this, thank you so much. Tomorrow, once again, we will meet at 10 o'clock, same venue, with new session. Thank you so much.